I am praying leave, my lord, to file, my lord, 2 appeals without certified copy, my lord.
Date of the order. Date of the order.
My lord, 25th February, my lord, within time, my lord.
Within time.
Yes, my lord.
Okay. Leave grant.
stay application.
My lord, I would like to bring to your lordship's kind notice
My lord,
from the bar itself.
My lord.
My lord, an incident took place on 25th April, last Friday at around 4:45 p.m. All my learned friends who was having their chamber at 6 Old Post Office Street, they were geared out by hordes of people in the name of, in the garb of certain case. They not only abused them, heckled them, assaulted them in front of police, but they demean Honorable Justice Biswajit Basu. My lord, kindly take cognizance of this and kindly seek report from either OC Hare Street or CP Lal Bajar. My lord, several complaints have been lodged. My lord, along with the police.
Friday at about 7:15 p.m. Mr. Bikram Banerjee had come to the chambers of the OSD, narrating about that he is not able to go to his chamber, etc. And he made a representation. I put it to the Registrar General to do the needful. She has immediately informed the OC as well as the DC of the area. In that endorsement, I said to inform the Learned Advocate General and request his intervention in the matter. I was informed subsequently about 8:15. The Advocate General, Learned Advocate General, had gone to that particular place with this police or somebody else. And then they sent a couple of photographs saying that the entire mob has been cleared and the road is free. This is what I know. And this is what I did at about 7:30 p.m. on Friday. In today's newspaper, whichever I buy, that Statesman and Times of India, they have not reported anything about this incident. If you want something to be done, please bring it on record.
It is on record. The pen drive is with us, my lord. My lord.
No, are you filing a petition?
Yes,
contempt petition. I seek, my lord. I mentioned the matter before the Honorable Single Judge, my lord, because his lordship's refusal to vacate the stay, my lord, set the Thames on fire on the Friday. Now, my lord, the attitude.
See, the thing is, sir, it's a judicial order.
Correct. So, my lord,
if your clients are the opposite party,
it is not my client. We are not personally interested.
All
the
right.
person, my lord,
so people can't take law into their hands.
No, I am not saying so. I am the petition that has been affirmed. Our role is, my lord, at best, my lord, informer and relative.
Yes.
Number one. Number two, the pen drive, my lord, which is with us, my lord, this might, my lord, encourage your lordship or inspire confidence that the way, the manner in which the entire incident was orchestrated, my lord, it is clearly an onslaught, my lord, on the independence of the judiciary. My lord, it is for your lordship, my lord, to perceive that I'm extremely grateful.
My lord, just for the sake of your lordships,
only one.
That is that kindly.
And who are the people who created this ruckus?
I'm sorry, my lord.
Who are the people?
My lord, the people, they are the litigants. My lord, we are the advocates of this High Court.
Wait.
And my lord,
no. The people who created the ruckus, are they parties to the
are they parties that they are personally interested? And thereafter,
no. Are they respondents, petitioners?
With petition.
They are the Gunda. They are the, my lord. They, my lord, your lordships are asking me who are those persons.
Whether they are the parties in the case.
No, yes, particular. My lord, in a criminal contempt.
No, Mr. Bahas. Whether they are the petitioners or the respondents, private respondents. These people who created the...
In that matter, they are the petition. In that matter, before Justice Basu, they were the petitioner. They are the respondents. They are services.
Are you sure?
Yes, my lord, because the interim order that was granted against the interest of the litigants, my lord, who assembled there on Friday, my lord, created this absolutely.
All right, we'll take care of two situations. One is
whether they are party or not. Those who have assembled,
that we have to ascertain.
Nobody knows, but my lord, we have definite information with regard to 2 or 3 persons. They were the parties, my lord, in the proceedings. Their interests were hampered. And my lord, it is a fact that they, my lord, that they narrated the incident, they expressed their agony and affliction in the video or the TV television. They said that their rights have been prejudiced by reason of the order passed by the Honorable Single Judge.
Then, if their rights are prejudiced, they ought to have intervened in the matter by filing an application,
Right.
seeking for vacating the
That is
interim
not
order
there.
or modifying
No,
the
they
interim
have
order,
appeared.
something they should have
That
done.
is not there. They appear.
Whatever,
This is-
They appeared in that matter, but the manner in which, my lord, they orchestrated this
See,
thing.
No, that nobody is clear on that aspect. If a party to the litigation is the person who's seen in the video, then it is prima facie it is wrong, because he is already before a judicial forum
Correct.
seeking to expose his
Correct.
case, cause.
Correct.
And parallelly, he can't take to the streets.
Correct.
Either that can't be allowed, that
Correct.
can't be allowed. But will somebody be able to identify who
No,
are
that is this, my
Indian
affidavit,
Namadis.
and we have given, my lord, name of, we have elucidated with
three.
3 persons who were there, my lord, at that point of time,
Leading.
and who were the parties in the proceeding,
And while leading the mob.
leading the mob.
There may be a connection between these two groups. The groups who were behind the listing of the photographs of Justice Mantha and this group.
and they are stamping on the photograph.
Yes,
That is
Spitting, my lord, spewing
my
venom,
lord, Bar
spewing
today
gas,
came,
everything.
my lord, Bar today came here before your lordship only with one reason. We are scared.
And my lord,
Once I appear or anybody would appear against the state dispensation, he and she would face this sort of things.
But we have this video.
And this is the 144 area. What police was doing? When 40, 50 persons get out all these advocates, what police were doing then?
Page 5, my lord.
We have quoted the statement.
The entire disruptions took place within the vicinity of High Court. They had the audacity to attack advocates who were fighting cases before this honorable court. And they are the adversaries.
And this continued
And police were mere spectators.
4 hours. 4 hours.
A report may be called for at least.
May I make one humble prayer?
আরে সবাই মিলে বললে কি হয়?
At least a responsible officer.
আপনি বলুন উনি আমার গায়ে আসছে উনি পড়ছেন
আপনাদের রিপোর্টের কপি দেখছেন তো?
হ্যাঁ, দিয়েছি তো।
হ্যাঁ।
কমিশনারকে আজকে পাঠানো রিপোর্ট সই পাঠানো 27 permitted.
It's a prohibited area, my lord. Even then, my lord, they had the courage, my lord, to break the security, and not only that, my lord, defiance, my lord, cannot be countenanced, my lord. May I have the privilege to request your, my lords, my lord, kindly direct the Commissioner of Police to, my lord, to file a report, my lord.
Now, in that Annexure D,
Yes,
it is a complaint by Mr. Sudipto Das.
that's good, my lord. He is one of the
Dasgupta.
council.
He has named the acquaintance of Raju Das, namely Rakesh Shankar
Yes.
Chaudhary,
They are the parties.
Eshta Ila,
Yes,
Mirmoni Banerjee, several others have commented,
yes.
promoted and shared the post with ulterior motive for the. Who are these people? They are party to the litigation.
Applicant,
Intervener.
And my lord, your lordship will be amazed to see, my lord, that this group of people, my lord, who created, my lord, this.
My lord, the same fate as countenanced by my lord Justice Mantha, same fate has been countenancing by my lord Justice Vishwajit Basu. Kindly see what
My
they
lord,
did.
judiciary cannot be a soft target, my lord, by the people who are blessed by the state.
Once your lordship would pass order, your lordship would also
And
face same
judiciary
fate.
is the target. And your
Kindly see
lordship's,
what they did.
your lordship's tolerance, my lord, cannot be constituted as weakness.
This manner cannot be tolerated, my lord. And this happened within the vicinity of High Court.
Judicial tolerance cannot be constituted as a weakness.
Every
my lord, in
time
the
we see that
constitution.
judiciary is the target. Every time.
And police, my lord,
Whenever
will not
honorable
see, my
judge would pass order against their wish, this sort of agitation, this sort of hooliganism in the garb of all these things have been taken place.
my lord, the concept of judiciary includes the bar. my
The
lord.
image of my lord Justice Vishwajit Basu has been tarnished in such manner. They stamped on the photographs of my lord Justice Vishwajit Basu.
Yes, my lord, this continued for 4 hours. What was police
What
doing?
police did, I'm more shocked.
They
with
threw
the
bottles, they
manner of the
threw
police.
stones, they threw
Air Street
shoes.
PS is a stone
The
throw distance
lawyer.
away. At least 40-50 police personnel are always there in the High Court. What they did?
On the contrary, my lord,
Police
they allowed the persons to sit in front of the chamber number 10 in their chamber. How could they get the tarpaulin at that spot? Tarpaulin was brought by the police allegedly.
It was, police was playing a partisan role, undoubtedly.
Continued for 4 hours.
Sit there. One for
You can register it.
And my lord,
It will
this
be
has,
registered
Yes,
today, so I will take care.
I'm
But
extremely
these-
grateful, my lord.
this we have seen on repeated occasions, my lord. On earlier occasions also we have
My lord,
seen such kind of
That
behavior.
today the bar is
Inside the court also.
united by its ropes, my lord, not divided by, my lord, any political ideology.
No,
But,
if-
my lord,
if
this
they are- if
issue-
they are- No, if they are parties to a matter and they are already agitating their rights before a court, parallelly, they can't take to the streets.
Absolutely, absolutely. Question is, my lord, ultimate, subject to correction, whether it amounts to interference with the administration of justice within the definition of section 2C.
That will has to be considered.
Right. But apparently, my lord, it sends an indication that such conduct, my lord, possibly cannot be countenanced.
আগে রেজিস্টার হোক ওটা
Affidavit করে
Sir, you take down and
my lord,
type
it will
out
be
there,
listed.
huh? The two applications are directed to be registered. Registered. The learned advocates appearing for in the two applications. Is it petition or application? Petition. Petition are directed to serve notice in the office of the learned advocate general, the learned additional solicitor general, as well as on the learned secretary of the three wings of the bar. Let the matters, let the petitions upon registration be placed before the Chief Justice for necessary orders.
Grateful. Then go in a server ko bhi may it be listed day after tomorrow subject.
My lord, may I be permitted to file an appeal without certified copy? Because the matter is very urgent.
Date of the order?
The order was passed ex parte and it came to the
Date.
25th February 2025. Because
Within time. No? But then you have to file a section 5 application.
I will file, first of all, the leave be granted to file this appeal.
Leave granted. Application under section 5 of the Limitation Act to be filed.
Yes. Okay.
My lord, may I be permitted to mention, my lord, on for inclusion in the list, my lord, didn't appear fresh matter. My lord.
Your Lordship, may I-
Will come like.
The Lordship, may I permitted to mention my matter that I harass more than 6 months and become a sick, and I am come before you for needed justice. I filed a case that was on 24th January 2025, but no single hearing is done at this time.
What is the case? Civil case or criminal case? What is the
Civil case.
Civil
I want to change the court room.
No, it's a civil revision.
No. It is transfer on medical ground, primary section.
Section 24.
Writ
Writ petition.
Writ petition.
And it is in the list, running in the list.
Lordship?
Is
No, Lordship, it is. Lordship on single bench asked me to go before the Honorable Chief Justice. Then he assigned a court. I have enough pressure. I don't have emergency trial.
Did you mention before the single bench having determination?
Yes, Lordship.
And what was the direction given?
Yes, Lordship.
What direction that the single bench gave?
The single bench asked me that he has enough pressure.
Ah.
He has not time to take the urgency of this matter. He asked me to get.
Give the letter. Let us see. Let us call for the file. Let us see. You send it to somebody. Yes.
Your Lordship, may I be permitted to mention a matter? Your Lordship, praying for inclusion of my application, restoration application in the list.
Yes, madam.
I'm praying for enlisted the application.
Yes.
Strategy versus time leave. May I be permitted to mention one matter, Lordship? Is an quantum application filed in connection with an order passed by your Lordship while your Lordship was sitting with Honorable Justice Hiranmaya Bhattacharya, Lordship.
We are going to list it on some Friday.
Lordship.
I have discussed with the Lordship. Second half on some Friday we'll take.
Lordship, may I?
Please give.
Grateful, Lordship.
Lordship, may I be permitted to mention one original site matter subject to your Lordship convenience? My junior is there. May I hand over the order passed to your Lordship on 14 June 2024? It is a transfer pricing matter and it is analogous matter. 3 assessment years are involved and Mr. Percy Pardial is appearing. He is leading me in this matter. Subject to your Lordship convenience, my Lord. On 2nd May, your Lordship already fixed one matter where Mr. Percy Pardial is appearing. Our humble prayer before your Lordship. If your Lordship kindly bring the matter at least in the list. Subject to your Lordship convenience, if it is taken up, it is okay. Not, then it can be fixed on the next date. But at least we can try.
Mr. Basu, on that day we can't take it up. Probably we can list it. And then we'll try to give a date.
Yes, 2nd May.
The numbers. Yes,
yes,
sir.
my junior is there.
Yes.
Grateful, my Lord.
My Lord, this matter was heard by Honorable Justice Orish Tandon, Honorable Justice Procedural Mandal in August 2024, 6th August. Therefore, the judgment was reserved. It was an appeal against the termination of service by a single judge.
We'll assign it to another bench. You give the letter.
I'll give it.
You give the letter.
Because
enclosing the order last. When was the matter last heard?
6/8 it was reserved for 6.
You give the letter to the OSD.
Yes, sir.
Yes, sir.
My lord, this case was supposed to be heard before a single judge, but it was transferred to you because there is a appeal regarding against the parent order. So it is pending for one long year. It will be better if you transfer the case to Justice Sabyasachi Bhattacharya. It is for transferring the inquiry matter to CBI. The police authorities did not go by the direction of the apex court in Lalita Kumari case.
Appeal is pending before this bench.
Yes, my lord.
We can club this matter along with the appeal.
It has been clubbed and upgraded, my lord. We are waiting for 1 year. It was filed in 2024. It is 1 year, my lord.
Did you see the cost list?
Yes, it is appearing as item number 36.
From serial number 61. Applications which were filed as early as 2010. Nobody has taken steps to move. It is we who have listed all these matters. The other day, 99 matters we listed. So don't say 1 year and other things. Nothing has been done. You give, let us see what can be done. Yes?
My Lord, kindly allow me to have one mention, please. My Lord, I have come from Murshidabad. My Lord, I'm petitioner in person and advocate in person. My Lord, my matter is very urgent. That's why I have come from 5 hours far from Baharampur, Murshidabad to Kolkata. My mother has also come with me. My Lord, the matter is that myself is an advocate, practicing advocate, but now I'm a petitioner in person, my Lord. My Lord, I'm a victim of outrage of modesty, my Lord. My Lord, this incident happened with me in 2018, and the person who did this with me in his official chamber, he was an additional SP of that district in 2018, my Lord. My Lord, then when I resisted this incident against him to his senior authorities, and when I approached this Honorable High Court, then he took revenge with me, and he filed several false cases against me by his so-called agents and suo motu police personal cases against me, and he harassed me by giving false cases against me from 2017 to till onwards. Myself, my lord, myself is a victim at first of the outrage of modesty, and second, myself is a victim of again of the several false cases against me from 2017 onwards, my lord. My lord, also in 2024, suddenly I met with a severe road traffic accident in which he was the primary attacker, and he wanted to kill me in the Murshidabad. And I was in the ICU, and laparoscopy has done in my abdomen, in my upper abdomen, and 1 liter blood clot was taken out by the best surgeon of the Murshidabad, Mr. Gulgulia. My lord, I'm medically not so fine, and I'm in medical treatment. My lord, I'm praying that as I have approached to this Honorable High Court, Honorable Justice Jason Gupta, he provided me a government bodyguard as he listened that I'm a victim of that incident, and also I'm an lady advocate, my lord. He provided me protection, government protection. But my lord, from 2017 onwards to till 2025, it's 8 years, a long gap. I'm a victim of several false cases. Being an advocate,
What are the matters which are pending in the High Court?
all are that I have filed criminal revision. Yes, my lord.
So you want the criminal revision to be listed?
To be, yes, my lord, to be assigned before Justice Jason Gupta, because he heard all my matter in limine and he understood my matter. My lord, it is not possible.
No, as per the present determination, which bench will hear the matter?
My lord, it is before Justice Ajay Mukherjee.
So if the matter is substantially heard by another bench, then if you mentioned before the Honorable Justice Mukherjee, he may release the matter, then the file will come to me.
My lord, then again I have...
cannot, on the administrative side, pull out a file. If the Honorable Judge feels that the matter was heard on several dates by Honorable so-and-so Judge, and it is substantially heard by the other bench, he can release the matter, and then the file will come to me, then I will consider for assignment. So you make a request before the concerned bench or before Justice Mukherjee saying that this was substantially heard by another bench, subject to whatever orders his lordship pass.
My lord, then I'm praying before my lord, as because my house is very far from Kolkata.
You can appear online.
Today?
Today also.
My lord, my phone is always in track. He's always tracking my phone.
So that is
Always
all.
I'm location tracking.
If you want, you can mention today in the second half also.
Okay, my lord, I got the point, my lord. I have to pray for the release before the concerned judge.
You will have to convince the judge that the matter was heard by another bench, substantially heard. Otherwise, you can argue before Justice Mukherjee himself.
My lord, I don't want to argue. My lord, I feel myself very ashamed and feel very uncomfortable to urge and to tell everything in front of every judges. I feel very uncomfortable. My lord, I have made the application to address you that I want assignment.
I can't assume jurisdiction now. Unless and until the matter is released, I will not be able to.
Assign.
On the administrative side, I cannot do. So you mentioned before Justice Mukherjee, and if he is convinced, he will release it. Okay.
Then the matter will be assigned, my lord.
If it is released, I will assign.
Okay, my lord. I will do that. Thank you, my lord. Thank you, my lord.
Lordship, আমার mentioning Honorable Justice অনন্যা বন্দ্যোপাধ্যায়ের কোর্টে আমার একটা ম্যাটার সিও পেন্ডিং অনেক দিন ধরে আপনার রিঅ্যাসাইন করার পরও সেটা পেন্ডিং রয়েছে কিছুতেই এটার হিয়ারিং মানে এটার এন্ড হচ্ছে না কারণ সেটা আপনার নোটিস আনতে আমি ক্যান ফাইল করে আমি ওনার কাছে করেছি উনি ক্যানটাও শুনতে চাইছেন না পেজ 6 প্যারাগ্রাফ 8 পেজ 6 প্যারাগ্রাফ 8
All right, receive it. Next, please call.
Lordship,
appellate side, Delhi list, serial number 1.
Job.
1 million.
What is the correction, sir?
I don't know. Suddenly it has come in the list. Last.
No, we find no grounds to issue this. It should be no grounds. Matters listed under the caption for to be mentioned, stating that in page 3, paragraph 4 of the order, the sentence has not been properly framed. The last sentence in the paragraph shall stand modified to the following effect, inverted comma. Therefore, we find no grounds to issue the direction as sought for by the petitioner in this regard. This order shall form part of the order dated 17/4/20.
Last sentence of para 4.
Typography.
Serial number 2.
Serial number 2, I am for the appellant, kindly taken up next week. The stay application.
Stay petition not filed.
Filed, my lord.
It is ready, man. Service.
All right, the learned advocate for the appellant requests the matter be adjourned to enable the appellant to file the stay petition. List the matter after the stay petition is filed in the admission list. Next.
Serial number 3.
My lord, I beg your pardon, please, my lord. My lord, I have prepared one application to address to you regarding the assignment. My lord, what should I do?
That I can't receive it. We have already we are not here to advise. You are an advocate, you know better. Yes. Item 3.
Serial number 3.
This is my appeal, my lord. I appear for the appellants, my lord. What was challenged before the Honorable Single Judge is a notice under Section 4 of the Public Premises Unauthorized Documents Eviction Act 1971. Now, my lord, the main thrust of the appeal was two. One is that it is a privately owned property where the appellant is a lessee for 99 years, and thus being the fact, my lord, there is no jurisdiction of the estate officer to invoke Section 4. Another one is that there is no grounds mentioned in the my lord, the notice impugned, whereby that makes this notice contrary to the provisions of Section 4, subsection 2, clause
That
A.
is on the merits of the matter. The estate officer has jurisdiction to invoke Section 4.
Yes.
Whether it's a private property, public
Yes.
property, etc., it's your defense.
Yes.
So you better answer to the notice.
Yes. That, my lord, on merits, I can answer, my lord, if your lordship so pleases. But, my lord, your lordships will also consider the effect of non-mentioning of grounds.
That's an excellent ground. That's an excellent ground for
My lord,
you,
that
sir.
makes the notice, my lord, subject to what your lordship say, completely ex facie illegal, and that there being no grounds given to me, I cannot reply to anything. It will be, my lord, akin to asking a defendant.
Let us see the notice.
My lord, the notice your lordship will find at page 53 and 54. 53 is the email through which it was forwarded to me, and it is at page 54. My lord, it reads, whereas I, the undersigned, am of the opinion on the grounds specified below that you are in unauthorized occupation of the public premises mentioned in the schedule below, and that you should be evicted from the said premises, then it says grounds. So, my lord, unless these grounds on which the satisfaction is drawn is given to me, my lord, in the notice, my lord, I cannot possibly reply.
Now, what happened to your writ petition?
My lord, the writ petition, my lord, I was directed to go before the, my lord, the estate officer and take, my lord, my defense of title, inter alia, my lord. But I say, my lord, and it remains, my lord, true.
Sir, please give Public Premises Act.
Yes.
My
lord, may I also hand over, my lord, another copy if your lordship so require, my lord? Yes. My lord, I draw your lordship's attention, my lord, to Section 4, subsection 2, clause A. And then, my lord, the rules and the forms also.
Yes, who appears for the estate officer?
I am for the estate officer.
Sir, as per Form A, it says grounds. So you'll have to mention the grounds. He has just, cut paste the form and has issued.
We have mentioned that, whereas I, the undersigned, am of the opinion on the ground specific below that.
Where are the grounds?
Where are the grounds? Well, it is a substantive notice. Well, ground may not be mentioned. He is an unauthorized occupant.
No. Sir, the statutory form which has been prescribed under subsection 1, clause B, 2 I's of subsection 2 of the section 4 specifically states. Otherwise, how will he respond to this notice? You issue a fresh notice.
It has been mentioned that you are unauthorized occupant.
No.
He can say
grounds.
He can go and
My lord, in view of the judgments of the Honorable Supreme Court, grounds, my lord, this is an old grant property. GLR we have produced before the single bench. It's conclusive proof. Nothing remains in this, my lord.
only this is a technical error that no specific grounds. He is an unauthorized document.
All right. Where is this decision 2019-20 SEC?
Yes, my lord.
My lord,
Kai
that
Khosrow,
is,
my lord,
my lord,
may I
that
present-
is on the basis of the original jurisdiction to issue.
My lord,
This is a defective notice. These are two.
Yes, I could
These
have
are two
had,
different grounds.
I could have had also, my lord, this is the judgment, my lord. Paragraph 50 was taken note of. Paragraph 49 and 51 immediately thereafter was not taken note of, which says, in case bona fide dispute is raised regarding
No, that
title,
is different.
may I at least complete? Then the jurisdiction is not there with the officer concerned to even issue the notice. Paragraph 51. The very next paragraph, even 49. আচ্ছা আচ্ছা আমি দেখে নিচ্ছি পড়ছেন পুরোটাই পড়ছেন
So no jurisdiction to invoke the powers under 4 by resorting to summary procedure.
Yes, PP Act is a summary proceeding, section 4.
Please come. This intra-court appeal.
Now, may I raise answer to this issue?
Yes, yes. Please sit down.
May I answer to this? Kindly see this judgment, my lord. Kai Khosrow, my lord. Kindly see paragraph 5, 6, 7, and 8. In this case, my lord, 5, 6, 7, and 8. The history has been set out. In this case, my lord, if your lordship see paragraph 5, then in last lines, then in turn, leased out suit property on 10/10/2029 to the government of India. Government India took it on lease. Next paragraph, my lord. Again, another lease was executed in favor of government of India. So government of India was itself behaving as if it is not the owner. Then kindly see, come to paragraph 7. It is now requisitioned. Government of India cannot requisition its own property.
Actually, that is why in the last paragraph,
That is why now
they said file a civil suit.
Yes, my lord. Now I will kindly see this judgment, my lord, of Usha Khanna.
That is the direction contained in paragraph 51.3.
Yes, my lord. Here, my lord, issue is this is an old grant property. Usha Khanna elaborates the history of cantonment land in respect of Usha Kapoor. In respect of old grant properties, my lord. Your lordship, kindly, I will not take your lordship through the, kindly see paragraph 13. Several judgments of this court have, or Supreme Court have been referred to. Paragraph 13, may I read it out? The decision in court in Chief Executive Officer and Surendra Kumar Vakil and considered the legal effect of entries in GLR, which registered is required to be maintained by the military estate officer of the cantonment under provision of cantonment law and administration rules framed in exercise of powers under section 280 of the Cantonment Act 1924. The general land register maintained by cantonment board under the Cantonment Act and rules framed thereunder is a public document, and the entries therein are conclusive evidence of title. This is the view expressed by the court in two other decisions, namely Union of India versus Ibrahimuddin and Union of India versus Kamla Verma. Apart from a decision in Chief Executive Officer versus Surendra Kumar Vakil, the reference to the nature of holding, that is old grant, and the nature of rights of holder, that is occupancy right, in GLR extracted in our considered view is conclusive of the fact that the land is covered by an old grant and the rights enjoyed by the appellant were merely possessory or of the occupancy right in respect of structures thereon. Now, kindly see paragraph 14. There is another small aspect of the matter which would require mention. Against serial number 6 of the extract of the GLR above, the class of the land has been described as B3. The aforesaid description of land is relatable to Rule 6 of the Cantonment Land Administration Rule, which is follows. Class 6, Class B land. Class B land shall be divided by central government or such other authority as they may empower in the behalf into the following subclasses, namely Class B3 land, which is held by any private person under the provision of the rule, or which is held by may be presumed to be held under provision of Cantonment Code of 1899 or under any executive orders previously in force, subject to the conditions under which the central government reserve or may reserve to the. In Union of India versus Roberts Omaya.
No, in your case, in the GLR, it is recorded as a government property.
We produced we were directed to submit a report. We submitted the.
But then the notice is defective.
Yes. That is different. That is not lack of jurisdiction. If I may kindly say that.
That is why I use the expression defective. The defect can be rectified.
My lord, yes.
Lack of jurisdiction means everything goes. It is not that. Defective notice can be rectified.
Can be rectified. My lord, our case before the trial, this is substantive notice. You are claiming that you are a private in this Union of India.
If you have said one line, as per the GLR entry, the land has been registered as so and so, or classified as so and so.
Yes.
You are in unauthorized occupation. Therefore, this Form A notice is issued.
That would have been the appropriate manner.
That to be done.
If your lordships have done your finding or Milord, having an opinion on the jurisdiction, Milord, and the GLR being the Milord proof of title,
you hear the order. This intra-court appeal by the writ petitioner
is simply
directed against the order dated 21st April 2025 in WPA 1135 of 2022. The said writ petition was filed by the appellant challenging a notice issued under section 4 within bracket 2 of the public premises within bracket eviction of unauthorized occupants bracket close Act 1971. The petitioner questioned the said notice as being defective in as much as the grounds on which section 4 was invoked were conspicuously absent in the notice which was challenged in the writ petition. The learned single bench by the impugned order was of the opinion that the challenge to the show cause is premature, and the petitioners, though have sought to make out a defense of title over the subject property, but such defense has not yet been taken in the eviction proceedings in as much as reply to the show cause notice has not yet been filed. Therefore, the learned single bench observed that it is always open to the petitioners to set up a title over the subject property as a defense, and if such defense is taken, the estate officer is obliged to address the same. The state, on behalf of the state, reliance was placed on the decision in the case of so and so, reported in 2019-20 SEC, page 705, which in the opinion of the Honorable Single Bench was not applicable to the facts and circumstances of the case. Accordingly, the writ petition was disposed of by directing the appellant to file a reply to the notice issued under section 4 within bracket 2, for which time was extended. Aggrieved by such order, the writ petitioner has filed the present appeal. You have elaborately heard the learned advocates for the parties and carefully perused the materials on record. Section 4 of the Act, you have to abbreviate it on top, deals with the issue of notice to show cause against order of eviction. Subsection 1 of the section 4 states that the estate officer, if the estate officer has information that any person is in unauthorized occupation of any public premises and that he should be evicted, the estate officer shall issue in the manner provided under the Act a notice in writing within 7 working days from the date of receipt of the information regarding the unauthorized occupation, calling upon the person concerned to show cause why an order of eviction should not be made. Subsection 1 capital A will not have application to the facts of this case. Subsequent 1A and 1B. Subsection 2 states that the notice shall, within bracket A, specify the grounds on which the order of eviction is proposed to be made. Under the rules,
There is also Rule 3, my lord, which your lordships may be pleased to consider. Form of notice and orders.
under the public premises eviction of unauthorized occupant bracket close rules 1971, rules have been framed in exercise of the powers conferred under section 18 of the Act. Rule 3 would be relevant for the purpose of this case, which deals with form of notices or orders. It states, a notice or order under the Act shall be in the appropriate forms appended to these rules. Form A is the form of notice under subsection 1, and clause B, small b, 2 i's, within bracket 2 i's, of subsection 2 of section 4. It is not in dispute that the notice which was impugned in the writ petition has adopted form A, which has been prescribed in the rules. However, the statutory form after the first paragraphs mentions grounds, inverted comma. This presupposes that the authority who is issuing the notice has to specify the grounds on which the order of eviction is proposed to be made. This is a statutory mandate in terms of section 4 within bracket 2 within bracket small a of the Act. However, the estate officer, while issuing the notice, has missed out on giving the grounds on which the proposed order of eviction, the order of eviction is proposed to be made. Therefore, it is not a case where therefore it is a case where there is it's a case where the notice impugned in the writ petition is defective for such reason alone. With regard to the other grounds which have been canvassed by the learned advocate for the appellant, those are all touching upon the merits of the matter, and we fully subscribe to the view taken by the learned single bench that the appellant, though sought to make out a defense of the title or the subject property, but such defense has not been taken in the eviction proceedings in as much as the reply to the show cause notice has not yet been filed. Therefore, all arguments which have been made by the petitioner touching upon the merits of the matter cannot be gone into at this stage, except to state that the notice impugned in the writ petition dated 6th January 2025 is defective. If such is the position, the respondent, namely the estate officer, should be empowered to issue a fresh notice removing the defect which has been pointed out above. For the above reason, the appeal is allowed, the order passed in the writ petition is set aside, and the writ petition is allowed to the extent by directing the notice, by setting aside the notice issued under section 4 within bracket 2 of the Act dated 6th January 2025 with a direction to the estate officer to issue a fresh notice clearly mentioning the grounds on which the proposed grounds on which the grounds on which the direction to specify the grounds on which the order of eviction is proposed to be made. Such revised notice be issued by the estate officer within 10 days from the date of receipt of the server copy of this order, and giving an opportunity to the appellant to submit their reply, and thereafter to proceed to take action in accordance with the law. It is made clear that the merits of the contentions which have been raised by the petitioner have not been gone into. It will be well open to the petitioner appellant to raise all contentions in response to the notice that has been directed to be issued by the estate officer.
My lord, kindly, instead of 10 days, kindly make it 30 days, my lord.
Or my lord, maybe please only to give them liberty and leave it upon them when to give the
To
notice.
challenge our order.
No, my lord, I
You
will
challenge our order.
my lord, kindly not take us amiss.
You don't say what we need to do.
My lord,
You-
only
in our
prayer.
understanding, this is what you get.
My lord, only prayer I may make, my lord, that all points, my lord, maybe.
That has already been made clear.
Section 5.
Instead of 10 days, my lord, kindly make it 30 days. We need some time for administrative purpose.
All right, 30 days.
Well, section 5 says even evidence can be produced.
Yes.
My lord, the
In
affidavit.
fact, we have delivered a judgment, the other division bench, elaborately we consider the, in respect of a premises in Dalhousie House building. Dalhousie. Dalhousie.
Yes.
Yes, next.
Lord, those that matter, my lord, the points, my lord, your lordship has been
Yes,
pleased.
sir, we have said so, sir. Probably our English is not as good as yours. So what to do? Next.
Grateful, your lordships.
You give the number to Shabhi. Next.
My lord, I am for the appellant, my lord. This is
what
my
is
affidavit of service. My lord,
Mediation
petitioner
period.
before your
Mediation
lordship is, my lord, very
Mediation period.
unfortunate,
Father,
old,
son.
ailing father approaching this honorable court. My lord, kindly have a
Oh,
look.
this matter, I don't know. Where is the son?
My lord, I have served, they have received it.
What can be done about it?
My lord, only thing, my lord, my lord,
Wait, sir, wait.
my lord, only,
Please wait.
my lord.
It was referred for mediation. Father, mother went, son did not come. Now what to be
No,
done?
son appeared.
Ah.
My lord, he was not agreed. My lord, kindly visualize the situation. There is a house.
Then you file a civil suit. What else?
My lord, kindly.
Police
my lord,
cannot enforce.
only thing, my lord, the AO, my lord, petitioner before your lordship is a 77 years old and ailing person. My lord, what the son is wanting, my lord, kindly visualize the situation. There is a, my lord, house, two-storied house. My lord, I am residing in a 2-room and son is residing in a, my lord, another 2 rooms. And rest portion,
Sir,
there
we
is a,
can't do that in a 226 matters. What you are saying?
my lord,
We tried our level best because your client was old and ailing. Yeah, he is
my
under
lord, under
treatment.
the, your lordship knows, my lord, under the maintenance and welfare of parents and senior citizens.
File a petition.
Yes, my lord.
File it.
Yes, my lord. What I am, my lord,
Take
approaching.
note of the recent Supreme Court judgment. You go before the authority.
Yes, my lord. My lord, section 24, I am, my lord, section 24 of the Act of 2007. My lord, I have the, my lord, opportunity to approach, but the learned single judge, my lord, directed me to, my lord, one criminal case is pending against the, my lord, Sean. My lord, my lord, one criminal case is pending against the, my lord, Sean.
What did the learned single bench do?
Single bench, my lord, directed that, my lord, I have to approach before the civil court for eviction of my son. My lord, if I approach before the, my lord, under the Act of 2007, then civil court is also bar.
Don't add words to the order. It says, therefore, it shall be open to the petitioner to institute appropriate proceedings for eviction of the private respondents in accordance with law. You go under the Act, you go for civil court.
My lord, what I am, my lord, kindly visualize the situation, and my lord, he is a deathbed almost. My lord, ailing condition. I will approach to the, my lord, maintenance tribunal, that is SDO, and collector is the authority. Section 24, kindly have a look into the section 24 of the Maintenance Act.
This intra-court appeal by the
My lord, I kindly give me liberty so that I can approach before the maintenance
directed
tribunal, my lord.
Dated so and so in WP number so and so. The petitioner came before the learned writ court by expressing a grievance against the 7th respondent, who is none other than his son, and the 8th respondent, who is the daughter-in-law. The 7th and 8th respondents are practicing advocates.
Not practicing advocate, my lord.
No.
No. My lord, I have given 3, my lord, shop room for his. He is a businessman. I have executed 3 rooms.
Different.
And there is also, my lord, flat. I wanted to.
Learned single bench disposed of the writ petition, leaving it open to the writ petitioner to institute appropriate proceedings for eviction of the private respondents in accordance with law.
And kindly see last 4 paragraphs also see kindly. Ample protection given. Internal page 3, last 4 paragraphs.
Furthermore, the learned single bench observed that the private respondent shall not commit any offense against the writ petitioner and his wife, and if any further cognizable case is alleged, the police authority shall register an appropriate case and take necessary steps. Further, the police authorities were directed to explore the possibility of instituting a proceedings under section 107 of the code if required. Full stop. Further, the police were directed to keep sharp vigil at the locale and ensure that no breach of peace takes place, and surveillance shall include frequent visits by police patrol in the area. Further, it was observed that if any untoward incident occurs or is apprehended by the writ petitioner, he shall be at liberty to call up the officer in charge, Kalyani Police Station, who shall then act in accordance with law. In our view, the learned single bench has sufficiently safeguarded the interest of the writ petitioner and issued appropriate directions. Therefore, apart from that, no, as noted above, the learned single bench has also given liberty to the appellant to approach the appropriate forum in accordance with law. When the matter came up earlier, taking into consideration the relationship of parties, namely the father on one side and the son and daughter-in-law on the other side, we directed the matter to be referred for mediation in the district court by the district judge, by the learned district judge Nodia. It appears that the mediation proceedings was initiated. As could be seen from the report of the learned mediator, District Legal Services Authority Nadia, the mediation was fixed on 20th of March 2025, and both the parties appeared along with their advocates in the mediation process, and the process of mediation was explained to both the parties. Further, the report states that the meeting and discussions had been held between the parties jointly regarding the matter in dispute, and a separate session has also been held with both of the parties, but the matter could not be settled in the process of mediation. Therefore, the case records were sent back to this court. So, considering the factual situation, since the parties are not at ad idem, then the only remedy open to the petitioner is to approach the appropriate forum for necessary relief, for which liberty had already been granted. We further clarify, it will be well open to the petitioner to invoke the remedy under any of the statute as he may be advised to seek for appropriate relief in accordance with law. With the above observation. Since already a case has been registered by the Kalyani Police Station in case number 844 of dated 16/12/2023 under section 341, 323, 506 and 34 IPC. The same shall be investigated and final report be filed within 6 weeks from the date on which the server copy of this order is. All the liberties and observations made by the learned single bench are preserved. Next.
Not sure. Serial number 5.
Grateful, man.
Serial
So
number
that I
5.
can approach before the maintenance tribunal. Grateful, man.
5 and 6.
5 and 6.
If you will be kept with the record.
Affidavit of sir, please.
I am for the respondent writ petitioner.
Well, in 5, my lord.
There are two, just next. There are two appeals filed by one Food Corporation of India, another by the Central Warehousing Corporation. The issue involved in this matter is, my lord, due to fight between two central organizations, my admitted amount claim has been withheld. And Learned Single Judge directed them to make payment. Now they are saying who will make payment?
May I, my lord? This is my appeal, my lord. My lord, the matter is slightly different than what my learned senior friend.
No, you go your own way. You make
Though it is fighting between us, my lord, but I have got nothing to do with the writ petitioner, my lord. And my lord, first I will try to submit, my lord, from this aspect only, whether, my lord, may I just formulate 2 or 3 points, my lord, what would be my grounds of challenge, my lord? My first and foremost ground of challenge is whether there is a privity of contract or not between me and the writ petitioner.
Which is your appeal, M8806?
I am the appellate in
806.
6, I am the appellant.
Number, case number.
806 is mine, my lord.
735 is mine.
MAT 806 of 2024 is by the FCI.
By the FCA.
By the FCI, my lord.
And that was CWC.
Central Warehousing Corporation.
Yes.
So, my lord, before I place the my lord judgment impugned, may I just, my lord, formulate or summarize 3 issues, my lord. What are the grounds of my challenge? First ground is the primary importance.
Tell, what was the prayer in the writ petition?
My lord, prayer is for the, my lord, the
You show that, no?
release of the money, my lord.
You show the prayer, sir.
Prayer is, my lord, at page number of my writ petition, my lord, stay petition rather, my lord.
55.
Yes, 55, my lord. Read in the nature of mandamus, commanding the respondents without naming anyone specifically, disperse the amount deducted from petitioner handling and transport bills on account of.
And who did the deduction? Your client.
I did the deduction from my lord CWC, and we are within our rights, my lord. What exactly?
FCI deducted.
And the deduction money, my lord, what it can transpire from the my lord, record is this, my lord. The admitted amount which you have deducted from CWC is around 27 lakhs. From my accounts, it is coming to 20 lakhs, and from his accounts, it is coming to 27 lakhs and odd. It is on record, my lord. Admitted, if we take that amount as an admitted amount of deduction, then as per my calculation, it is around 20 lakhs, and as per the calculation of CWC, it is around 27 lakhs. And the judgment impugned passed a direction to disburse the amount of 1 crore 46 lakh. That is my lord prayer B. May I read, my lord, prayer B? A writ in the nature of mandamus commanding the respondent, each of them, their servants, agents, and assigned not to withhold any amount as deducted from petitioner handling and transport bills on account of damage charges amounting to rupees 1 crore 46 lakh 67,382. This whole amount, my lord, has been directed to be disbursed by both the, my lord, FCA and CWC, either jointly or severally, whatever. Now, my lord, apart from privity of contract, my second leg of argument would be this amount has never been substantiated. There is no iota.
Your first ground is no privity between the writ petitioner and FCA.
Myself. Whatever contract, my lord, the written contract there is, that is between the, my lord, the CWC and the writ petitioner. I'll my lord, place that, my lord, the written agreement. What are the terms of the agreement?
The second is?
Second is, my lord, this
1.46,
how this amount is coming, that has not been substantiated, established by any scrap of paper. Thirdly is, my lord, admittedly these claims are time barred because the letters that were exchanged by the writ petitioner without, my lord, expressing any my lord, admission of liability, all, my lord, ends within 13 and 14. And the writ petition was filed, my lord, 18. And the claims for which, my lord, the demands were placed is all, my lord, arising.
Deduction took place in 13, 14.
12 and 13, my lord. The amounts that the writ petition is claiming is for the period 12 and 13.
Writ petition filed in 2018.
And fourthly, my lord, there is an arbitration clause in the contract executed between the writ petitioner and the CWC to adjudicate whatever the dispute is.
Yes.
And, my lord, the fifth point is touching the same issue. It is a disputed question of fact, my lord, touching the issues of contract in which the court should not, my lord, generally intervene. If the dispute relating to contractual dispute, my lord is aware of, then the court should not intervene unless the dispute is prima facie, my lord, admissible. Now, my lord, if I place the agreement or, my lord, the contract executed between the CWC and the writ petitioner, my lord. That is, my lord, is appearing in the can 1 of the my lord, application filed by CWC. They have attached that, my lord, contract with their stay application. Can 1 of MAT number, item number 6.
Can 1 in FMA 735.
735, my lord. MAT 735.
Page 735.
No, 10 number.
Mat koto? If, my lord, kindly comes to first the parties to the agreement. That is at, my lord, before that, my lord, the clause for arbitration is appearing at page number 11 of the MTF, my lord, model tender form, my lord. The first document they have attached is agreement. There is a separate agreement on the issues of, my lord, the arbitration.
The agreement starts at page 23.
Agreement has, yes, 23, my lord, yes. If I read the first part only, the Central Warehousing Corporation having agreed to grant the regular contract of handling and transport of food grain and allied material at Central Warehouse, Rani Nongor, such and such address is given in response to submission of sealed tender by me on such and such, the regional manager, Central Warehousing Corporation, Kolkata, I, Sri Sunil Saha. This is the agreement or disclosure in the form of a declaration, my lord, is given by the writ petitioner, I, Sunil Saha. Thereafter, if my lord turns to the next page, because the clause governing the arbitration is on the next page, my lord, the first paragraph. All disputes and differences arising out of or in the any way touching or concerning the agreement, whatever, except as to any matter the decision of which expressly provided for in the contract, shall be referred to sole arbitration of any person appointed by the Managing Director, Central Warehousing Corporation, New Delhi. It will be no objection of any appointment that the person appointed is an employee of corporation, that he had to deal with the matters to which the contract relates, and that in course of his duties as such employee corporation, he had expressed views and all or any of the matter in dispute or differences. The award of such arbitration shall be final and binding on the parties to the contract. It is a term of this contract that in the event such arbitrator to whom the matter is originally referred being transferred or vacating the office or being unable to act or resigning for any reason, the Central Warehousing Corporation at the time of such transfer, vacation or office liability to act shall appoint another person to act as an arbitrator in accordance with the terms of this contract. Thereafter, my lord, the other clauses are there. Though this clause is, my lord, knows they cannot appoint the arbitrator, but the arbitration clause will remain. That it should be referred to the arbitration. Now, my lord, kindly sees the parties to the, my lord, this contract. That is at my lord, page number 39, my lord. Or before that, my lord, kindly comes to page number 38. Definition, my lord, the contract definition has been given. First, thereafter, my lord, the term contractor shall mean and include the person or person, firm or company with whom the contract has been placed. Thereafter, the definition has been given. Thereafter, my lord, the term corporation and the Central Warehousing Corporation, wherever occurs, shall mean Central Warehousing Corporation established under Warehousing Corporation Act. That is the, my lord, the another appellant. Then, my lord, the next page, parties to the contract, Roman 3. The parties to this contract are contractor and the Central Warehousing Corporation represented by the regional manager or any other person authorized or acting on this behalf, the person signing the tender or any other document forming part of the tender on behalf of any other person or firm shall be deemed to warrant that he has authority to bind such other person. In other words, my lord, I am not reading the whole clause. The parties are also been defined. So far, my lord, the FCI is concerned, I have not come across a single line or phrase or word, my lord, where it is appearing that the agreement is back-to-back an agreement which has been executed between FCI and CWC. This is an independent, separate, and, my lord, and sole agreement that has been executed between the CWC and the writ petitioner. And what are the consequences, what are the scope of, my lord, this contract, everything has been mentioned within the part of this agreement, my lord. I am not, my lord, referring to each and every part of this contract. My lord, thereafter, my lord, the period of contract has been, my lord, mentioned. Thereafter, my lord, the liability of the contractor for losses has been there, my lord. I can refer a small note to mentioning these clauses. What I am trying to, my lord, demonstrate here is this agreement is very self-contained one, my lord, and each and every, my lord, the rights and obligation of the parties, that is CWC and writ petitioner, those have been, my lord, very in detail articulated in this agreement, including, my lord, the agreement for arbitration. Apart from that separate agreement, my lord, there is a separate clause as well within the parameters of this contract, my lord. If I just show that clause once, that is a separate arbitration, my lord, agreement, and thereafter, my lord, there is a separate clause as well for arbitration. That is page number 52. Page number 52, my lord, Roman 19.
52.
Yes.
Yes, my lord. If my lord kindly see the Roman 16 payment, how the payment is to be made, by whom the payment is to be made, that is mentioned there, my lord, Roman 16. And at the bottom, my lord, arbitration clause 19. So why I am, my lord, demonstrating all these things? Because, my lord, the arbitration clause was mentioned in the MTF. That apart, my lord, also additionally, they executed a separate agreement containing the arbitration. So therefore, my lord, this clause is of very great importance to, my lord, to show that the whatever dispute that arises between the parties, my lord, is to be decided by arbitration. Even though, my lord, it is settled position of law, the writ court can intervene, but there are certain conditions. When in presence of the arbitration clause, my lord, the writ court will intervene. I'll place the decision, my lord. What are the grounds that has been fulfilled here or not? So that is, my lord, first, my lord, the leg of my submission was this. As per this agreement, my lord, I am nowhere. So whatever the dispute that is to be, my lord, if at all there is any, that is to be decided between the two. Now, my lord, the second, my lord, the ground of challenge, if I take, that is, my lord, that amount. My lord has seen in the prayer that amount has been described 1 crore 46 lakh, and the whole amount has been given. So, my lord, the reason for this claiming this amount can be, my lord, seen from their letters. If my lord kindly takes my stay application once, it is there, because I have attached a writ petition. The writ petitioner, my lord, sent total 6 letters, addressing sometimes me, sometimes to the CWC, and in those letters, my lord, he has mentioned those figures. So, my the first such letters dated 10th of May 2015 is appearing in page number, my lord, of my writ, of my stay petition at 108. This letter was addressed to me. This is the first letter, my lord. The last, or I should say, the oldest letter, my lord, addressed to me, claiming the amount for 2012 and 13. I'll just, my lord, read the relevant paragraphs. First paragraph, my lord, they have mentioned. Second paragraph, my lord. With full satisfaction of all concerned, I submitted my bills for payment of transporting and handling charges with all necessary documents. However, in a surprising manner, my bills have been withheld. On inquiry, I have been told that an amount of rupees 27,98,100, rupees 63,22,822 from my bill for the period September 12 and November 12, and my lord, 23,52,000 and 2,94,000 for the period of September 13 has been deducted from my amount as an damage charge. The first paragraph, my lord, mentions certain figures, which in total comes to around 1 crore 17 lakhs. After taking the whole amount together, my lord. Thereafter, my lord, kindly comes to the next letter, that is on page number 114. That was subsequent letter, my lord, dated 8th of April 2017, again addressed to me. In this letter, my lord, the amount will increase. The first paragraph, my lord, he has mentioned himself to be the successful bidder. Thereafter, in surprising manner, an amount of rupees 27 lakhs 98,100, 63 lakh 22,000 from my bill for the period September 12, November 12, and 23 lakh 52,000 and 2 lakh 94,000 for the bill of September 13 has been deducted as damage charges. Subsequently, a further amount of 29 lakhs has again been deducted from my bills as damage charges. So this, my lord, the last line, 29 lakh, that has been added for the first time in this letter, without, my lord, referring to any period. So, my lord, the period that the writ petition is referring to, basically 3 months, September and November 2012 and September 2013. And if the total figure, the total amounts, if you taken together, my lord, then this figure comes to 1 crore 46 lakh. Thereafter, my lord, similar letters, my lord, page number 120 to 122, my lord, similar letters, my lord. Thereafter, my lord, 17 to 19, 20, 22, 23 to 25, 125, 126 to 128. Total, my lord, I can see from the writ petition, 6 letters, my lord, from time to time he has sent, stating the same, my lord, figure. So, if at all, my lord, the basis of the claim, what we can find from his writ petition is those letters, without, my lord, annexing any, my lord, supporting proof in claim thereof. In the middle, my lord, may I submit one thing?
What
In-
was your reply? Did
Yes,
you?
we have given the my lord affidavit in reply. We have disputed.
No,
we have,
you have not sent any reply to the letters.
no, we have. Oh, I'm sorry. We did not give any reply to those letters because we had no contract with them, my lord. Now, my lord, in course of hearing before the learned single judge directed us to file the whole, my lord, vouchers or bills that we paid from the year 2012 to 2015, my lord. So we had submitted before the, my lord, learned single bench. We have also attached with this writ application. From that also, my lord, I try to show what are the admitted documents that we have filed before the learned single judge, the vouchers submitted by the writ petitioner, and what are the amount I have paid. That was, my lord, subsequent stage it arose. So these were the letters, my lord. Now, my lord, the CWC also sent 3 letters to me, mentioning that certain deduction was made, and they are also seeking reversal of those, my lord, deduction, so that they can, my lord, make the payment to the writ petitioner, my lord. The first such letter of CWC addressed to me is appearing page number 91. In between, my lord, I just summarize the mechanism how we work. Food Corporation is a big organization, my lord. We have got hundreds or thousands of, my lord, depots all over India. But in certain cases, there is paucity of, my lord, depots. Then generally hire. Sometimes we hire from the private party, though is very minimal in number. Sometimes we hire from private party. Sometimes we hire from the central warehousing corporation. And what are the understanding or the agreement between him? It is this, my lord. The whatever the bills, my lord, the contractor will charge them for handling that, my lord, the food grains. He will, my lord, claim that amount. And on top of that, my lord, we provide 8% amount more for the, on account of the supervision that they maintain.
8%.
8%. So basically, my lord, on 8% of profit, the CWC, my lord, works. The working condition between FCI and CWC is 8% of profit, my lord. So the amount that we pay, my lord, once that they raises the bill, then we also scrutinize the bill, and you also scrutinize, my lord, whether the claims are legitimate or not. In certain condition, my lord, what happens? The food grains comes in rake. Rake means, my lord, the whole, my lord, the wagon, the whole train, my lord. It enters into the, my lord, the depots. Now, there is a, my lord, window of time is given by the railway within which, my lord, the food grain is to be uploaded. Yes, my lord, is loading and uploading. If that time, my lord, taken beyond that, my lord, then the railway, my lord, charges amount to us. That is the demurrage charges. We sometimes call demurrage charges. Sometimes we call warfare charges. So those charges, my lord, if we find fault with the, my lord, CWC because of them, because he is in charge of the handling. Maybe he is doing this through the contractor, my lord, that is writ petitioner, but he is in charge of this thing, my lord. So, my lord, whenever we find fault in supervising those things, my lord, whatever the damage or the, my lord, the charges is been is imposed upon us, we deduct that amount. So in this case also, my lord, we deduct a certain amount that is there, my lord. We my lord, instituted 3-member committee. After the committee was formed, my lord, in the 2012, my lord, the committee came to a conclusion. It was because of the defect or, my lord, my lord, the latches on the part of CWC, that the damage charges was imposed upon us by the railway. Accordingly, we deducted that amount. Now, my lord, the question is whether that decision may be right or wrong. So whatever that is, my lord, the decision was taken by the FCI in the year 2012, and that decision has never been challenged either by the CWC or by the mother writ petitioner. The writ petitioner cannot, but be that as it may, my lord, that decision of, my lord, the coming to conclusion by the CWC that there was a latches on the part of CWC, and accordingly we can deduct an amount of around 23 or 24 lakhs. I'll place that, my lord, the 3-man committee report, my lord. That decision was taken 2012, and the CWC never challenged that decision. Now, my lord, the first letter of CWC addressing to us seeking the reversal of the said demurrage charges is appearing page number 91. That was dated, my lord, 3rd of January 2013. The area manager, Food Corporation of India. Please refer to office letter number such and such, dated 10th of April 2013, regarding recovery of 27,98,000 affected by FCI towards demurrage charges from H&T, means handling and transport bills, for the period September or November 12, amounting to rupees 63,22,820. My lord, this amount 63 lakhs is the total amount, and out of that, my lord, he is raising allegation that 27 lakhs we have deducted on account of recovery on account of demurrage charges. Since the rake was placed and handled by CWC during the above period when there was no space at the warehouse, and FCI also requested to accommodate the rake by delivering the stock against DO issued by them, the recovery of 27 lakhs and odd effected from H&T bills is not only arbitrary but also unjustified. In view of the above, it is once again requested to release 27,98,100. So at all, any amount, my lord, that has been admitted by them, not me, my lord, by them, that figure is coming 27,98,000. Now the deduction is right or wrong, my lord, that issue has been already decided by our 3-member committee, where we concluded that it was because of the defect, because of the, my lord, the latches on the part of the CWC. Now, my lord, the next letter. 92. Another letter, my lord, on a subsequent date, 10th of April 2013. Again, on similar line, my lord, it is observed that from the H&T bills of rupees 63,22,000 for the period of September and November 12, your office settled payment of only such and such amount after making recovery of 27 lakhs and 98,000 on account of alleged DC means, my lord, demurrage charge, WC means, my warfare charge. Thereafter, my lord, he sought the reversal of that amount. That was the second letter. Thereafter, my lord, again the next page 94, third letter addressed to us, where, my lord, the figures has been mentioned. How much was the bill and the deduction amount and WC amount. If, my lord, kindly comes to serial number 9 at page number 94. They have given a description of several bills up to 28 bills where, my lord, we have imposed or sometimes did not impose demurrage charges. The serial 9 and 10, serial number 9 and 10 is of, my lord, applicable here. In serial number 19, my lord, can see the date is there, October 10, 2012. DC amount 20 lakhs and WC amount 7,93,000. So if we add this, my lord, period 20 lakhs and 7 lakhs, this, my lord, that particular figure is coming. And at the next, my lord, next column, my lord, period is mentioned, my lord, September 2012. So as per them, my lord, the 27 lakhs and odd we have deducted. We have indeed deducted, my lord, but as per our calculation, it is not the 27 lakhs, it is around 23 or 24 lakhs. I'll show that figure, my lord. But indeed, we have deducted. So, my lord, serial number 9, they have mentioned, my lord, the whole amount of deducted amount. Thereafter, serial number 10, my lord, that is for the month of November 2012, because for 2 months, my lord, for the year 2012, the requisition claiming the amount. So, September, they have mentioned, and for November, 49,600. 49,600. So, my lord,
WC means
warfare charges. Warfare charges. Certain window limit, a technical term, my lord. If we use the platform beyond certain period, my lord, then if we unload the food grains and keep it on the platform, there are also certain hours is given to us by which we have to again clear that platform. If not done, then warfare charges is imposed. So if, my lord, kindly see from this document, if we can see, then I can find from the letters of this CWC that 27 lakhs and odd is deducted on account of, my lord, WC and DC. There is no whisper of other amount that has been claimed by the writ petitioner. Now, if for a second, my lord, I can.
Total is?
Total is, my lord, that figure is matching. 20 lakhs and 7,90,000 is coming to, my lord, 27 lakhs and 98,000. That amount
is 8 crores 39 lakhs. No, 83 lakhs 98,740.
Serial number 9 and 10 for that period.
Only serial 9.
Serial 9 and 10, my lord. Because he is claiming for those period, my lord. In the letter of writ petitioner, he is claiming, my lord, September 12, November 12, and, my lord, November 13. Only for 3 months period he is claiming, as per his claim, my lord. So that is why here, my lord, the November 13 is not covered. So I can show only these 2 months of period from their letter, 27 lakhs and odd. Now, my lord, for a second, my lord, I will produce that, my lord, the 3 committee report. That is at, my lord, my lord, it is all part of the writ petition, my lord. It starts from 85, 86, 87, 88. From 85, my lord, we can see amount of DC on the left hand side, 29,40,000. No, sorry, 2,94,000. All of the heading goes like this: investigation report of committee in respect of high demurrage charges of each rec dispatch X behind such and such to JPG unloaded at Jalpaiguri for the period September 12, my lord. Since my lord, the railway imposed the DC, my lord, we conducted the inquiry, then we came to finding that DC is 2,94,000. My lord has seen it, amount of DC. Thereafter, my lord, page number 87, which has been typewritten in 2000, page number 88. 87 is the actual page and typewritten on 88. Here, my lord, again, amount of DC and WC, 23 lakhs 52, 2,35,000. DC is my lord 15 lakh 58,000, WC is 7 lakh 90,000, total liability is 23 lakh 50. It should be 23 lakh. They have mentioned typewritten, wrongly typewritten, my lord. It should be 23 lakh 52,000. So, my lord, 23 lakh 52,000 and 2 lakh 94,000 means around 3 lakhs. So, 27 lakhs, 26 lakhs and odd. It is slightly mismatched, but be that as it may, my lord. At the best, my lord, so far the admission of the parties of deduction, not the liability to my liability towards the writ petition. So far the admission of deduction is concerned, my lord, the amount is coming around, as per my calculation estimation, around 26 lakh, around his estimation 27 lakhs. So therefore, my lord, no here this amount of 1 crore 46 lakh that has been directed to be paid is getting established. Now, if I place, my lord, the judgment impugned once, my lord, what is the wrong as per my lord submission, the committed by the landed single judge? And before that, my lord, I'm sorry, before that, in our stay petition, as I submitted earlier, my lord, the landed single judge directed us to file all the vouchers, my lord, bills submitted by the writ petitioner, I'm sorry, CWC, on account of those bills for 12 to 15. So we have deposited that, my lord, deposit and made an, my lord, calculation. So that would appear, my lord. (157) of my stay application. Report in the form of affidavit filed on behalf of the added respondent. I'm not reading it. The report is also not so important, but I have given the Excel sheet wherein the deduction for the relevant period will appear.
Page?
Page, my lord, is at I'm sorry, my lord. I'm 172, my lord. 172, 173. This 172, 173 is the summary of the bills, my lord, that we attach with that report. This is a very, my lord, the letters are very small, I can understand. On the left hand side, my lord can see September 12 is there. It starts from September 11, October, November, December. Thereafter, my lord, starts from January 12, then September 12, my lord can see. Thereafter, my lord, the amount has been mentioned on the third column, on the head DC amount with damage charge amount, 20 lakhs and odd. So it is matching with their figure. So we are admitting that 20 lakhs for that period, 20 lakhs we deducted. Here only, here, my lord, WC is not mentioned. So even if for argument's sake, we admit that amount. So on total, it is coming around 26
lakhs.
26 and odd. It is not mentioned here.
And according to CWC, it is 27 lakhs.
So it is allowed, we are getting around 26 lakhs. Now, my lord, November 12, my lord, can I see it is blank because we could not get hold of the bills for those periods. We have mentioned in our report for November 12, we could not find. But the CWC will assist us from their document. I can show, my lord, what was the amount. November. Now, my lord, kindly comes to on the bottom part, September 13. September 13, my lord, there are two bills. September 13. September 13 has been mentioned once, but there are two figures, 70,908 and on below that 1,46,000. My lord, thereafter we deducted amount very less, 33,600 we have deducted. In other words, my lord, the deducted amount was only 33,600. And rest amount
that is in respect of one bill only.
Yes, my lord.
The
September 13.
Other bill, no deduction.
No, that is not dispute, my lord. He is claiming, my lord. May I repeat, my lord? That is at the cost of repetition. He is stating for claiming the bills on 3 occasions, for 3 periods, September 12, November 12, and September 13. He is concerned with only those 3 months. September 12, November 12, and September 13. As far his letters are concerned, my lord. So that is why, my lord, only for those periods I am showing this deduction made. Because other periods, even if it is there, my lord, it is nobody's case that it is a right justified or not, my lord. We are concerned with these 3 months. So from our, my lord, bills that we submitted before the honorable landless single bench, my lord, the figures has been mentioned, the deduction. This, my lord, report has not been, nobody has filed any exception to this report, my lord. So I can, my lord, take it that this report has been uncontroverted, has remained uncontroverted so far. Unfortunately, my lord, this report has got no reflection in the order judgment impute hearing. Now, my lord, if I place the judgment with that.
Page 4 from para 8.
Yes, yes, my lord. Absolutely. My lord has taken a note of it. Because paragraph 6 is my submission, I am not repeating this. But my lord, perhaps page 4, bottom part of paragraph number 7, there is a finding. If I read it.
Please.
The last line start from the middle of this paragraph. Why? While CWC says that the petitioner was providing H&T services to FCI as the depositor of CWC at the central warehousing Raninagar, FCI disputes the claim of the petitioner on merit without denying its liability to the claim, my lord. So this is no here, my lord, we have admitted any liability. I will show from my affidavit in opposition as well as, my lord, line of, my lord, the action taken by this. This finding is also, my lord, without any basis, without denying its liability to the claim. Because we have denied our liability so far the claim of the writ petition is concerned through our affidavit in opposition, also in course of, my lord, hearing. FCI stand is, in fact, FCI having made payment of a substantial amount to the petitioner in terms of the bills raised by WC for the work done by the petitioner. My lord, this report, we have mentioned how much amount we, my lord, paid and how much we deducted. So, my lord, the landed judge, my lord, the landed single judge, my lord, perhaps was misled in believing that we made this payment to the writ petitioner. Well, we cannot. Whatever the bill raised, we paid to the CWC, and accordingly, CWC made the payment. So, yes, my lord, for all those years, we have made the payments, but not made the payments directly to the writ petitioner, which has been held by the landed single judge in this paragraph. Now, my lord, paragraph 8. Curiously, both CWC and FCI take the same objection to the writ petitioner, namely that of limitation and disputed question of fact. With regard to limitation, although tenure of agreement was from 11 to 13 and again from 13 to 15, there is sufficient evidence of a recurring and continuous cause of action. My lord, kindly appreciate this is a money claim, sort of a money claim. So money claim, my lord, very strict, my lord, law of limitation apply. That is 3 years, unless any written, my lord, admission of, my lord, liability is there. The petitioner raised the bills on CWC and CWC demanded the money from FCI on 21/2014. FCI intimated its inability to make payment of 6/6/2014, my lord. Well, unfortunately, a wrong letter has been referred to. This is something, yes, my lord, so this 6/6/14 that landed single judge has referred to, my lord. This relates to, my lord, the CWC dispute. Not at all, my lord, admitting my liability for the writ petitioner. The petitioner made a number of representations thereafter to FCI as well as the CWC starting from 14 to 17, including an application and Right to Information Act 17 to 18. The petitioner sought information from CWC on account withheld by CWC from H&T bills of the petitioner for the warehouse at Raninagar, Jalpaiguri. The present writ petition was thereafter filed in 18. Hence, there is no delay in filing the present writ petition. With deepest of regard, my lord, I could not understand the very basis of this finding. Because there is no admission of.
So where is the 6/6/14 letter?
6/6/14 letter, my lord, may I produce? Page number 95, my lord. This letter is at page number 95. This is our letter, our letterhead, my lord. Date is there 6/6/14. Addressed to the CWC. Please refer to this office earlier correspondence as well as several telephonic discussions regarding uploading of the rice consignment X such and such by increasing stack height up to 24 and utilizing storage space up to 120% to avoid any unnecessary detention of rake, and DC thereof. In this connection, this is once again to inform that the referred rice rake XFCPA has already been placed at Jalpaiguri railway siding and railway free time starts from 6 a.m. morning. On placement of the said rake, the FCA official, including ICCS and district squad members, have attended JPG, that is my joint committee. I cannot read it, Mala. This very morning and found no men and machineries from CWC, Raninagar present there to start uploading the consignment, perhaps. Then and there is
uploading operation.
Operation, Mala. Okay. Then and there, the matter has been informed to you over phone with request to depute sufficient men, machineries to start uploading.
This doesn't concern anything.
Yeah, nothing. Yes, absolutely.
Payment.
Because it is our case, my lord. What was the actual dispute? The consignment already come, and CWC is telling there is not enough space. And as per our estimation, there was a space, and they could increase beyond their capacity. It is generally practiced, my lord, up to 120%. They can, my lord, accommodate the food grain. Rightly or wrongly, my lord, we were insisting them to do this, my lord. And accordingly, since they did not do this, there was a delay, admitted delay. For the delay, again, my lord, I submit. Writ petition has no liability because of us, my lord, delay was caused. That is true, my lord. But the delay, since the delay was there and railway imposed that penalty upon us, so we deducted from him, my lord. So, in other words, my lord, the 6614 letter has got nothing to do with our liability. Thereafter, my lord, next paragraph. The court is unable to accept the other objection with regard to disputed question of fact and money claims. Thereafter, my lord, the decision has been referred to. It concludes that writ under 26 of the 226 Constitution of India maintainable for asserting contractual rights against the state or is instrumentally as defined under Article 12 of the Constitution. The Supreme Court reiterated the legal principle laid down in such and such. A writ petition involving a consequential relief of monetary claim is also maintainable. In any event, when the court finds the existence of any factual dispute which are outside the jurisdiction of the writ court, exercising discharge power under Article 226 of the Constitution of India depends on the individual facts of each case, my lord. So this case also says, my lord, we all know, if the facts are admitted, then definitely the money claim could have been, perhaps, if it is in the period of limited, could have been allowed. Here the facts are absolutely on dispute. Who is at fault and how much is the amount involved? There is no way, my lord, this amount claimed by the writ petition has been established, except and without those 6 letters, my lord. Then the next paragraph, my lord. On merits of controversy, it is evident that the petitioner has been unfairly treated by both CWC as well as FCI. The petitioner entered into an agreement with CWC for handling and transporting food grains belonging to FCI. Damage charges, if any, was foisted on the petitioner by reason of act of omission or commission on the part of FCI and CWC, my lord. We have not foisted any, my lord, damage charges upon them. It is upon the CWC. Hence, neither of the respondents can seek vindication from their accountability by putting the ball in each other's court. The dispute between the CWC and FCI would also evident from the letter of CWC FCI on 10/4/2013 requesting the FCI to release an amount of approximately 27 lakh which was deducted on account of damage charges. That is between CWC and FCI. Next paragraph, while CWC is primarily responsible for payment of the petitioner bills for the work done, and there is no dispute that the petitioner did perform his contractual obligation, the FCI is the sole disburser of the money to CWC, which CWC would then pay to the petitioner. The FCI's denial of the petitioner claims on merit also link the petitioner and the FCI with sufficient clarity in respect of FCI's liability. FCI in fact says FCI has already made payment of such and such amount to the petitioner, which shows that the FCI cannot escape from its liability for withholding a substantial amount of money from the petitioner's bills. My lord, we have not deducted any bills from anybody's bills, my lord. And so far the liability is concerned, my lord, again the court has come to a, my lord, the misplaced finding that 43 lakhs we have paid to the petitioner. No, my lord, we are paying to the CWC. So therefore, my lord, making payment to the petitioner never arises as far as the FCI is concerned, my lord. Significantly, neither CWC, should I continue? Significantly, neither CWC nor FCI has given any satisfactory response or defense as to why the amount of 1,46 lakhs was withheld from the petitioner handling and transporting bleach when the damage charges were incurred by reason of FCI and CWC failure to provide warehousing space for storing the food grains. Well, this amount is to be established by the writ petitioner, not us, my lord. The onus of proof upon the petitioner to show that the 1,46 lakhs is payable to him. though it has got no connection with me, since my lord, the liability has been fastened with us, my lord, that is why I am stating all these things. This amount, since they did not discharge our primary liability to establish this figure, my lord, so therefore no further onus was, my lord, transferred to us to disprove this part, no, not 1 crore. But be that as it may, my lord, from the records, only 27 lakhs and odd is appearing to be a deducted amount. Whether liable or not, that is a different aspect. It is even more significant that the CWC assured the petitioner the relevant point of time that no amount shall be deducted from the petitioner bills and the admitted the petitioner claim without raising any dispute. Moreover, FCI letter to CWC on 6/6/14 requesting the letter to take steps for creating sufficient storage space on top priority basis so that the substandard food grains can be uploaded at the earliest, so that the inability of the creating that space was on account of CWC, or at least between CWC and FCI, for which petitioner cannot be made to suffer for consequences. Even if, my lord, the petitioner cannot be made to suffer the consequences, but that doesn't mean, my lord, the FCI would be liable to make that payment. It is one aspect, but it is one thing to say, my lord, because of the dispute between CWC and FCI, the petitioner should not suffer. But it is another thing to say, my lord, that because of the sufferance, my lord, the FCI will pay. Because I am only concerned about myself, my lord. Although both the respondent rely on no demand certificate on such and such date, my lord, one no demand certificate was, my lord, submitted by the CWC, from which it appears, my lord, the contractor has said for a certain period they did not they have any claim. So on that respect, the court has said the court does not wish to place much reliance on that document, since it is a common knowledge that the contractors are coerced into signing such certificate as a condition for release of pending dues. I do not know, my lord, what is the basis of this finding. It is a general, my lord, remark without any, my lord, findings so far any, my lord, substantiation of allegation is concerned. And it is not his case that this particular no due certificate was executed by exercise of force or fraud or coercion. In any event, the no demand certificate does not indicate anywhere that a deduction made from the petitioner bills were included in the scope of certificate. It is also admitted that petitioner went several representation on account of damage charges to the respondent independent of no demand certificate. Thereafter, my lord, another paragraph, my lord, what happened, my lord, in another case involving the similar issue was filed before this honorable court, involving the same, not same, my lord, another contractor. So in that case, the decision came out, my lord, and that particular decision, the FCI were not fastened with any liability. So far the payment to the handling contract was concerned. So we refer to that decision, my lord, but the court has distinguished that judgment on certain facts. I do not find any reason why. Thereafter, my lord, paragraph 17, my lord, that is the basis of the judgment. The fact narrated above makes it clear that the respondents have deducted amount of, my lord, 27,90,000. That is all right. Thereafter, my lord, 63,22,282. I do not know, my lord, where from the learned single judge has got this figure. Paragraph number 17. That is the very basis of this part. The facts narrated above makes it clear that the respondent have deducted amount 27,98,000. Therefore, 63 lakhs and odd. Thereafter, 23 lakhs and odd, and 2,94,000 for contractual time frame on account. So I am, my lord, harping on this issue, my lord. This amount has never been established by the petitioner. Thereafter, my lord, the ultimate judgment was passed. If I say read only that particular line, my lord. The court is hence inclined to grant relief to the petitioner also for the fact that petitioner claims have been pending since long, at least 2018 when the petition was filed. It is accordingly allowed and disposed of directly respondent, that is CWC and Food Corporation of India, as well as officers who have been added as party respondent to disburse the amount deducted from the petitioner handling transport amount such and such to the petitioner within 4 weeks from the date of judgment, without disclosing, even if, my lord, for argument's sake, I admit that both of us are responsible. How much we will pay, that is also not mentioned. Not even mentioned jointly or severally. The mode of payment will be same as was used by the respondent to make payment to the petitioner before filing the present petition. If the petitioner has any other preferred mode of receiving the amount, thereafter, my lord, the mode of payment has been mentioned. Well, in support of our defense, my lord, we cited several decisions before the landed single judge with a written notes of argument as directed by the landed single judge, my lord. I have attached that with my stay application. I just make a summary of those decisions. My lord is well aware of, but for my satisfaction only.
No, please.
That is at the fag end, my lord. Page number 287. These short notes, my lord, I submitted before the landed single judge as per her ladyship's direction. 287, my lord. There on the 288, my lord, there is a figure, my lord. What happened, my lord, once we file those vouchers, the CWC was also directed to file a reconciliation note, my lord. Unfortunately, that is not part of the either of our records, my lord, though I am carrying that list, my lord. So from the reconciliation note of the filed by the CWC and our Excel sheet, my lord, I made a just deep summary of these things, my lord. The first is, my lord, total claim amount I have made. Thereafter, HTC bill amount I have mentioned. Thereafter, my lord, how much the FCI paid, that I have mentioned. Page number 288. This amount, my lord, the landed court is, the landed single bench is taking that I have made this payment to the petition. I have made this payment. So far, from this calculation, my lord, it appears that out of 46 lakh to 43 lakhs, he has already got the amount. Thereafter, my lord, points of law I have said, and thereafter, my lord,
No, at page 28, that
288, my lord.
22,000. That figure is there, which was mentioned in the judgment.
Yes. 1,40,000.
2012. Page 288 of your written notes.
288, my lord. Same.
288 of your written notes.
288 of my written notes.
Second column, November 2012, claim is 6322,822. First column.
They are claiming as per their
That was
petition. I have
there in the
mentioned. Yes,
judgment.
as per their
What you
petition.
have said that this amount was never claimed.
No, that was never claimed. That was there is no manner out of these things, my lord, whether it was claimed or not. So far the bill, that is why I have said HTC bill. It was his claim as per the writ petition. But what is the bill amount? That I have mentioned, HTC bill.
Writ petitioner's claim.
Claim is 27 lakh, but the bill is 24. Claim is 63 lakh, but the bill is 15 lakhs, my lord. That is why I mentioned this figure to differentiate the issue.
First column is claim with the writ petition.
Claim next HTC bill.
Yes, sir. Where are the petitions, sir?
Yes, my lord. Thereafter, the next one decision I have submitted, though it is, my lord, the division bench of Bombay High Court, but the issue of limitation has been touched by this judgment. I will
paragraph.
I will paragraph, my lord, page number 6, internal page number 6, paragraph number 11 to 14, or my lord, running page number 294. Therefore, the question is one of discretion for this court to follow from case to case. There is no lower limit or there is no upper limit. A case may be brought within Limitation Act by reason of some article, but the court does not necessarily give the total time to the litigant to move this court under Article 32. Similarly, in a suitable case, the court may entertain such petition even after lapse of time. It will depend on what the breach of fundamental right and the remedy claimed or when and how the delay arose. Or it referred to some other Supreme Court judge. In the instant case, the period of limitation is prescribed under the Act. Even during the period, the petitioner had not filed the above writ petition. In fact, the petitioner entered into an agreement for the subsequent period without making any grievance on this behalf and request the first respondent only to waive the penalty of considering apostate period of the writ petitioner, as well as considering the fact that the writ petitioner has allowed his claim to become time barred by not approaching the appropriate court within the prescribed period of limitation. It is not entitled to any relief from this court in an extraordinary jurisdiction under Article 226 of the Constitution. Considering the apostate aspect of the matter, we have the opinion that if a party allows the period of limitation prescribed under the Act to lapse, it should not ordinarily be allowed to say that the petition should be entertained, as there is no period of limitation prescribed for filing such a writ petition. It was in respect of writ petition, my lord, this court came to that finding. Thereafter, my lord, another division bench decision of Odisha High Court. The decision of
Page 297, last paragraph. Correct?
Yes, my lord. Absolutely.
Next decision.
Thereafter, my lord, very important, I have noted. My lord, para 11, my lord. Para 11. We have wondered whether money claim, this is for Supreme Court decision. Oh, I'm sorry, man. This is again High Court decision, but based upon certain Supreme Court decision, that is why I have attached this. Division bench judgment. We have thus wondered whether money claim suit for which has become barred by limitation can be allowed in jurisdiction. The answer obviously is no. The learned single judge has brushed aside the valid plea of appellant in limitation by referring to direction issued by petition of such and such. Thereafter, paragraph number 14. We may, however, notice the judgment in such and such has been overruled by another judgment of Mafatlight Industries. We may further notice the Supreme Court in Tilok Chand.
We'll go through it. Next. SR Oil, page 304.
That is, my lord, specifically on the point of brevity of law. What happened, my lord? In this case, there was an agreement between the two parties, and they also engage another agency, my lord. So in that case, my lord, the principal, like FCI, they made certain payments. In that case, they made certain payment directly to the contractor because he was under certain duress, and the middleman in between could not pay. Even the Supreme Court came to a finding only because of that payment, no privity of contract is established. May I read just the relevant paragraph, my lord? It is a full bench decision, my lord. Paragraph number 13 is the dispute is summarized. The main issue which is involved in this appeal is about ascertainment of a person and liable to make payment to the appellant. There is no dispute with regard to quality or quantity of work done by the appellant state. It is not dispute that the appellant has not paid amount payable to it. It is also not in dispute that the appellant had not engaged by the respondent in pursuance of contract entered into between the respondent and the ONGC. And it was open to the respondent to avail services of any other person for doing the work entrusted to ONGC. In the light of the aforesaid disputed fact, the question is with regard to determination of liability of the person who has to make the payment to the appellant. Thereafter, my lord, the findings is at page number 20, paragraph number 23. May I read, my lord? Upon hearing the learned counsel and looking at the contract entered between the appellant and the respondent, and upon perusal of the other letter, we believe that the view expressed by the High Court cannot be accepted. It is true that ONGC had made payment to the ONGC directly on several occasions. Upon perusal of the correspondence, we find that some outstandings, understanding, but not amounting to any agreement or contract, was arrived at between the ONGC and the respondent for making direct payment to the appellant, possibly because the respondent was not in a position to make prompt payment to the appellant. It also appears that on account of delay in making payment to the appellant, the work of ONGC was likely to be adversely affected. The ONGC was interested in getting its work done promptly and without any hassles. In this circumstance, upon perusal of the correspondence which had taken place between ONGC and the respondent, it is clear that so as to facilitate the respondent, the ONGC has made payment on behalf of the respondent to the appellant directly. Simply because, next paragraph, simply because some payments have been made by ONGC to the appellant, it would not be established that there was a privity of contract between ONGC and the appellant. And only for that reason, ONGC cannot be saddled with a liability to pay the amount payable to the appellant by the respondent. It is also pertinent to note that the arbitration agreement was only between the appellant and the respondent. The ONGC was not a party to the arbitration agreement, like us. When a dispute has arisen between the appellant and the respondent in relation to payment of money, the appellant had initiated the arbitration proceeding. As the ONGC was not a party to the arbitration agreement, it could not have been represented before the arbitral tribunal. If the ONGC was not a party before the arbitral tribunal, the tribunal could not have made any award making the ONGC liable to make payment to the appellant. In the aforesaid factual legal position, the arbitral tribunal could not have made the ONGC liable at any respect, and rightly the majority view of the arbitral tribunal was to effect that the ONGC, not being a party to any contract of arbitration agreement with the appellant, could not have been made liable to make any payment to the appellant. This judgment came in respect of arbitration award. We are agreement with the view expressed by the majority of the arbitral tribunal. In an opinion, the High Court has committed an error in not considering the above fact, and by observing that the appellant will have to take legal action against ONGC for recovery of amount payment to it. If one looks at the relationship between appellant and respondent, it is very clear that respondent had given a subcontract to the appellant, and in the same agreement of subcontract, the ONGC was not a party, and there was no liability on the part of ONGC to make any payment to the appellant. Thereafter, the only last paragraph, the 28th paragraph, may I read. The learned counsel appealing for the appellant failed to show any document in the nature of contract entered into between appellant and the ONGC, whereby ONGC had made itself liable to make payment to the appellant. Even when the payment had been made by the ONGC, it was very clear that the payment were made on behalf of the respondent, as the ONGC was debiting the account of the respondent by amount paid to the appellant. It is important that the payment was made to the appellant only upon certification of work done by the respondent. The ONGC has given a contract to the respondent. The ONGC has never entered into any contract with the appellant, and therefore it did not rely upon any certification of any statement made by the appellant in relation to quantum of work done by the appellant. This fact is also so that ONGC was concerned with the work which has been approved by the respondent, and instead of making payment to the respondent, the ONGC had made payment to the appellant. Similar circumstances where only the better footing, perhaps in that case, was that they made the payment to the contractor. Unlike us, we did not make any payment directly to them. For the opposite, we do not agree. On PVT, I am skipping the decision, the next paragraph.
Part performance will not occur. This part performance judgment.
No, yes, that is yes, absolutely, my lord.
Then page 314, that head note itself is clear.
Yes, my lord. Yes. That is why I am not reading, my lord. Contractual.
Don't read. Then next. Three
221, my lord, contractual dispute, 321. Yes.
All right, we'll go through it. And where is the division bench judgment you said?
I'm a single bench.
Page
judge.
336.
Yeah, at the last, my lord. It is at the very last, my lord.
Oh, that is single bench.
That was single bench, my lord. That was no appeal was preferred, my lord, against the judgment. And may I just read one paragraph showing under which circumstances, even in spite of arbitration clause, it may lie, my lord. It's Supreme Court decision, my lord, page number 335.
336.
335, my lord.
335.
Then this paragraph number 7. In view of the so far the view taken by the High Court that the remedy by recourse to arbitration clause was available, paragraph number 7, 335. The appellants and therefore the writ petition filed by the appellant was liable to be dismissed. Suffice is to observe that the rule of exclusion of res jurisdiction by availability of an alternative remedy is a rule of discretion and not one of compulsion. In an appropriate case, in spite of availability of alternative remedy, the High Court may still exercise its res jurisdiction in at least 3 contingencies: where the writ petition seeks enforcement of any fundamental rights, where there is a failure of principle of natural justice, where the orders or the proceedings are wholly without any jurisdiction or the virus of the act or is challenged. The present case acted applicable the first 2 conditions. Thereafter, my arbitration clause was not invoked because it was the first 2 conditions are applying. In this case, this condition not applying.
Yes.
And the last decision was that single bench decision, my lord, similar situation, handling contractor was there, my lord. This is also dispute between CWC and FCI. The single bench directed the CWC to make the payment. That is, my lord, sum and substance of this case. My lord, my stake is highest because I am nowhere, but I am still saddled with this.
We'll continue.
Extremely grateful.
May I seek one indulgence? Very next matter.
Hmm.
Would it appear as to be mentioned tomorrow? Because, my lord, they are willing to, my lord, accept. This is regarding that 3 licenses, excise licenses.
Yes.
Lord, I think they are willing to accept, Lord, the renewal fees and, Lord, continue the license.
They have put a white flag. Why don't you consider?
My lord, only thing, my lord, will vacate those observations.
That definitely to be mentioned.
To be mentioned tomorrow.
But I have given the amount also mentioned.
Yes, we will just verify and we'll get back.
Or we can take it up today. No.
Tomorrow, Lord, kindly.
All right.
To be
Okay.
mentioned just tomorrow. Much obliged.
দাদা তোমার কাছে দেখো তুমি অ্যামাউন্টটা তোমার কাছে অ্যামাউন্ট
Yes, sir.
My lord, I beg to appear for the appellate in item number 6.
Yes. Oh, this is the other one. This is MAT 878.
Yes, ma'am.
Yes.
My lord, central warehousing, here is an intermediary. My lord, I have a contract with the HNT contractor. This was by way of a tender. We appointed the HNT contractor for the purpose, yes, the writ petitioner, for the purpose of handling and transportation. Now, my lord, we have depositors. Now, this particular subject go down is owned by us. Now, Food Corporation of India made a reservation. That is by an independent contract. Now, by virtue of that contract, my lord, a space is allotted. It is reserved for any incoming and outgoing consignments. My lord, here, if your lordship kindly takes up page 97 of my stay application. The agreement starts from page 85. As my learned friend has already placed this agreement, that it is an agreement between me and the HNT contractor, that is the writ petitioner. Lordship kindly comes to page 97. Page 97, clause 4.
Yes.
Clause 4. The term food grain shall mean and include wheat, paddy, rice stored, stroke handled, stroke transported on behalf of the CWC's depositor. My lord, this is the only perhaps clause which connects me, the depositor, the FCI, and the HNT contractor. This is the only solitary clause. Now here, my lord, the case begins with the fact that it is a deduction made from the bills of the HNT contractor. Now, why it is the deduction made from the bills of the HNT contractor is because when the HNT contractor performs a particular job, it furnishes bills to me. I add 8% service charge on that and then submit it to the depositor. Now, what is my function? What is the function of the HNT contractor? The contractor's job commences from by lifting the consignment from whether it is coming by train or by other means of transport. From there, transiting it until they go down. After transiting to the go down, since they are appointed by us, their job is also the stacking of the food grains or the consignment which lands there. From there, the job further extends where they transport it to the end station or wherever it is to reach. We are to supervise only within the precinct of the go down, not beyond.
Of your go down.
Yes, not beyond that. And for this purpose, we charge 8% service charge on the bills that are placed by the HNT contractor. Now here, my lord, we have an ongoing business with the Food Corporation of India. Food Corporation of India had reserved space in this particular subject go down. And due to the ongoing business, there have been bills which have been raised from time to time. Now, there were deductions made. Particularly the case of the writ petitioner is that there were deductions made on the account of demurrage charges. Now, my lord, here, demurrage charges is not an expense, but a loss which is sustained by the Food Corporation of India. It is a loss where the losses are of two kinds, my lord. First is demurrage charges, the other is a wharfage. Now, demurrage charges is where a wagon enters a particular railway station, the goods are there, there's a free time provided within which period the goods have to be unloaded from the wagon. If it is not done within that free time, any excess time per wagon, it is charged by the railway department. Wharfage is just the subsequent stage where it is on the platform and is staying on the platform, a particular free time is provided within which it has to be exited from the station. Now, here, by lord, the claim, I believe, comprises of these both components. Now, your lordship kindly takes up page 220. 220 of my stay application. This is the incident from where the demurrage charges was incurred. So basically, my lord, what Food Corporation of India is doing, it is to compensate its losses, which they had to pay to the railway department. They are saddling it on on the HNT contract.
Pass it on to him.
Yes, ma'am. If your lordship takes up page 220, this is a communication, and there are series of communications which I will be placing, which is between me and the Food Corporation of India. This is the exact cause of action for the causation of the demurrage charges. And the subject is availability of storage space. Sir, reference to the subject cited above, it is informed that on the date of the opening balance of the utilization of the space is 88%. Our rake is being unloaded. On receiving the complete rake, the occupancy level will be reached 104%. So now, my lord, here, initially there is a booking done. That is, if a rake is reaching a particular go down, the depositor has to inform us that this amount of rake is coming. So kindly make space so that they can be stacked. Now here, my lord, 88% of the reservation was already there. So if this if this rake comes in, they'll be now reaching 104%. That is beyond the 100% storage space. Now, this 4%, my lord, as my learned friend was arguing, 120% is permissible. It is permissible, I admit it. But here, there is a concept of FIFO. Now, what is FIFO? FIFO is first in, first out. Now, your lordship knows there are stackings done. Now, if a particular stacking reaches a height level of 10 bags, subsequently, if a rake comes, it has to be accommodated on top of that. Now, in FIFO condition, the ones which are already there has to move out first. Unless they move out, they cannot be stacked. So here, it was impossible to go to 120%, but to only restrict it to 100%, because they were in no time to be moved out. In view of the above, it is requested to take necessary steps to restrict further rakes placement, if any, on pipeline until and unless a good quantity of issue, but in no circumstances further rake could be accommodated in case of immediate placement, and for non-clearance of rake, CWC will not be held responsible for DC if any so assured. So we had made a caveat at the very threshold. That if your rake comes in, we will not be able to accommodate it.
You have informed them?
I have informed them by virtue of a letter dated 14th September 2012. Then your lordship kindly comes to page 221.
Yeah, this much.
This is a letter, my lord, which is addressed to the writ petitioner, HNT contractor. The subject is unloading of stranded rake ex parte. So by this time, it is already stranded. This is reference to your letter dated 11/9/2012 on the subject cited above. You are well aware that due to non-availability of storage space, the stranded rake could not be unloaded. Now the space is available on liquidation of stocks during last 2 days. It is therefore requested to start unloading from 8 a.m. 14/9/2012 positively and complete the same within the free time. Otherwise, DC shall be borne by you. So we had made a caveat here also to the HNT contractor that, look, if you do not unload and stack it up within the specified free time, then DC will occur. In this connection, it is also informal that as per assurance given by the area manager FCI, AO Jalpaiguri, no demurrage charges. Now, this was an assurance, my lord. I shall place that letter also, where the Food Corporation of India assured that there will be no demurrage charges. So that is what we were just communicating to the HNT contractor. Otherwise, if a demurrage charge occurs, then you are responsible for it. That also caveat we have made in this letter. Then your lordship kindly takes up page 222. This is letter dated 19th of September 2012. May I place it, your lordship? This is further to our letter number 295 dated 17/9/2012 on the subject cited above. Yesterday, 18/9/2012, there was no lifting liquidation of stock. Therefore, the position remain as such. You are well aware about the position as we intimated from time to time. Standard rakes is not being possible to clear until and unless a good quantity of issue is issued out. You will appreciate that due to acute space crisis, the standard rake is not possible to clear. Kindly arrange the maximum liquidation so that rake is cleared at the earliest possible. Here, my lord, on subsequent day, we are again informing the Food Corporation of India, the area manager, that kindly liquidate it as it was decided. Unless you liquidate or you move out the stock which is already there, we will not be able to accommodate the rakes, incoming rakes. Then your lordship kindly takes up page 223. This is also a communication which is made to the area manager of the Food Corporation of India. Subject clearance of standard rake. This is in continuation to our letter date number so and so dated 19/9/2012. This is in connection with the previous letter, my lord. On the subject cited above. Day before yesterday, that is on 19/9/2012, there was lifting of approx 650 metric ton. Yesterday, that is 20/9/2012, there was a bunk called by a political so and so, so and so, so and so, so and so took place. Well, next paragraph. There is
there is need for maximum liquidation
my copies
against
against
RO
the
issue. A good quantity of
a good
RO
quantity of
in hand
in hand, my lord, lifting so that
ensure
they can be cleared.
maximum lifting
In
so
sum and
that
substance, my lord, we are again informing them that kindly lift the
to liquidate demurrage.
yes, to liquidate further.
Then what was their response?
There were no responses.
And
There were few responses. I shall place them also. This is a subsequent page 224. This is their response. Kindly refer to the subject cited in this regard. Please be appraised that the wheat special X shillings SIR to Jalpaiguri has been placed and kept stranded since 15/9/2012 due to shortage of space at godown as per information received from your end. As sufficient RO has been issued upon CWC Rayanagar depot to respective stocks were lifted from the godown, which might create sufficient storage. Now they are apprehending that it might create. They are not yet saying for definite that a particular amount will be shifted to some other godown or will be moved out. In view above, it is requested to start uploading operation immediately from today, if needed. Kindly accept the stock in over and above the to avoid incurring high incidence of damages. Now here, my lord, they are on one hand saying that you accept the rake which is coming, but they are not saying that the reservation be extended. There is also no communication that the 100% reservation that we have kindly extended to 120 or 130. So unless, I tell your lordship, for practical purposes, if this storage retention is not extended, then if we raise the bills upon the FCI, they will not pay it on. Because they will take the plea that the reservation was of this particular amount of space, this is extended. And there was no communication, and there has to be, my lord, a formal contract. We are both PSUs, my lord, without a particular contract or anything in writing, your lordship knows that nothing will work apart. Then your lordship kindly takes up page 225. This is a communication made by Central Warehousing Corporation with the HNT contractor. Unloading of aforesaid wheat rake so and so. This is in reference to your letter dated 15/9/2012 on the subject cited above. You are well aware that due to the non-availability of storage space, the standard rake could not be unloaded. Now the space is available on liquidation of the stock. It is therefore requested to start unloading the standard rake from so and so 23/9/2012. So, your lordship, the rake arrived on 14th. It has been now taken into the godown, into the storage place on 23rd. So what will emanate from the correspondences between the Food Corporation and the Central Warehousing is that there was shortage of space. There was no diversion at this point of time until 2023, on 23rd, 2012. No order of diversion was made, no rebooking was made, no further extension of storage space was also made by the Food Corporation of India. Now, Your Lordship kindly takes up the report. Firstly, my lord, I take the serious exception to the report is because this report is made by the officers of the Food Corporation without inviting us. Now, my lord, if a partial report is to be made, an independent or the person against whom the report is being made also should be entertained for his objections. Your Lordship kindly, I will not trouble Your Lordship with the entire report. If Your Lordship kindly takes page 228, this is the typed copy, the observations.
Yes.
If Your Lordship kindly sees the observation portion. As per movement plan, stroke DIS, there were 4 rakes, that is 1 per week for Raidagar go down, Jalpaiguri, but 4 rakes, including 1 unplanned rake, rebooked, intercepted at Jalpaiguri. So apart from the 4 rakes which were to be there was another rake which was diverted to Jalpaiguri, instead of the fact that there was no storage space available. Now, from here, one more fact will emanate that unless the Food Corporation of India rebooks or intercepts its consignments, we as Central Warehouse, we cannot do it for them. It has to be done by them because the consignments are owned by them. Were already been accommodated by 11 September 2012, that is just before placement of the said rake, thereby keeping no sufficient space to accommodate the rake under which consideration. Warehouse manager, Central Warehouse has intimated his inability to accept the rake due to the non-availability of sufficient storage space to accommodate a full rake wide letter number so dated 6/9/2012, 10/9/2012, 11/9/2012, and 12/9/2012. So, my lord, the rake arrived on 14th. Prior to that, we have been informing them. This is an admitted position. We have been informing them that there is no space available in the godown. Kindly divert it or rebook it. In this regard, from the beginning, manager Central Warehouse CWC was unwilling to accept accommodate the rake beyond 100% utilization. So, my lord, this observation is baseless. We have informed them we cannot accept more than the space which is reserved by them. If a diversion has to be made, it has to be made by them. If rebooking has to be made, it has to be made by them. My lord, next part. Prior information given to higher authority about the above matter with request to take suitable steps on urgent basis, wide email dated so-and-so, reference number so-and-so, dated so-and-so, but without any response from higher authority. It is their observation that their higher authority has also not communicated with them. Rake was placed at time when the Central Warehouse go down at Jalpaiguri were jam-packed with over capacity utilization due to continuous rake placement over the previous 3 weeks. Admitted position. Availability of space creation could not be ensured due to delay on the part of the, my lord, this is wrong. This should be something else, I believe. It cannot be DC. Part of the DC. Distribution of lift stock from the godown as well as well, I'll be referring to the original document. Stock from the godown as well as non-availability, or my lord, this is attitude. So it will be non-accommodation of the central warehousing. And that is what they had alleged prior also, that the warehouse manager was not accommodating to accept stock beyond 100% capacity utilization is an instance in earlier occasion where stocks were allowed to be beyond normal capacity up to 127. Now, my lord, here this 127, as I had already submitted, my lord, this is only possible if FIFO could be accommodated along with it. If there was a free space where we could have allotted, we could have stacked, it was possible. But the difficulty is once it goes stacking up, my lord, now if one has to, if the consignment, the previous consignment has to go out, then they have to be again restacked. For this again, my lord, they will be not paying us for the labor charges.
Okay. So therefore, you are consistently maintaining a stand that demurrages cannot be levied on you
Yes, my lord.
for circumstances which you have set out.
My lord, this was the stand before the writ court also, before the single judge, that we are in a position where once they release the amount, we will be releasing in favor of the writ petitioner. We have nothing against
No,
the writ
but
petitioner.
then your stand with them was they were not justified in levying demurrage
Absolutely.
and warface charges
Absolutely.
for circumstances which
For
you have
these are the
set out.
circumstances. These are all admitted positions.
So therefore, that deduction was uncalled for, according
It's
to you.
uncalled for.
So
Absolutely
if the deduction is held to be uncalled for, they automatically get the payment
Yes.
through you.
Absolutely, madam. That is our stand.
But in your affidavit in opposition,
Yes, we said
you have
that.
taken this stand
Yes, madam.
supporting the
Yes, madam.
petitioner.
I will place my affidavit. We have taken this part.
No, that's enough.
We admit that they are supposed to receive the amount that they have claimed.
Without the deduction.
Yes, without the deduction. As far as my lord arbitrability is
But
concerned.
the learned judge has made both of you jointly and severally liable.
Yes, my lord.
It has not accepted your case. If the learned writ court had accepted your case and held that the levy of demurrages was illegal, consequence would be to direct FCI to pay you and in turn you to pay the writ petition.
That is why, my lord, I did not waste any time and took your lordship directly to the place, the situation, how this demurrage charges was incurred.
So from day one onwards, you are maintaining a stand that the circumstances you cannot be burdened with this demurrage. Consequently, the writ petitioner cannot.
My lord, if we had not made any caveat from the day one, that is 14th, even prior to that, we made caveats to them. If we did not make that, if we had acquiesced,
2012.
yes, my lord. If we had acquiesced, then we would be liable. If we would not have communicated with them or our HNT
and
contractor.
This report, in fact, in this report at 229, it is not a firm decision. It says probable reason of such incidents of high.
My lord, I was inviting your lordship to see the admitted positions. These are admitted by them. Had it been that the case of the FCI was different, then I would have contradicted with some other documents. But the very reason I'm relying on these is these are the admitted positions.
To start uploading work despite creation of space on 22nd 9/12. They have been recalled. Where is that?
But there was an arbitration clause between
lord,
yourself and FCA.
Yes.
You could have initiated that.
My lord, arbitration
the moment
clause.
they deducted, you could have sent them a notice of arbitration.
My lord, the arbitration clause that my learned friend was referring to was between me and the HNT contractor.
Oh, not between both of you.
No, my lord. In that case, he would be non-suited. So basically, I could not have claimed out from him. Arbitration would
but
have.
In your agreement between both of you, it is not an agreement.
No, my lord.
It is only a letter form.
The reason why, my lord, because we both come under the same ministry. So we have a reconciliation mechanism. Though it takes years and decades for reconciliation, if I may say so, but there is that mechanism. That is why we don't have any judicial or quasi-judicial mechanism for.
Ultimately, it's the public who get affected.
My lord, absolutely.
Because there have been instances where the rice bags which have been lying in the wharf or exposed to sun and rain have germinated. And lakhs of bags have been destroyed.
Huge amount of spillage, by huge amount of spillage.
In fact, somewhere we saw the spillage quantity could have been avoided.
Yes, there is a transit loss. There is a my learned friend provided a chart where there is a
pilferage.
Yes, pilferage.
Because once it has been transported in open wagon, pilferage, both coal and wheat or rice, both pilferage. There is a beautiful knack by which they do.
So as my learned friend was previously arguing.
But you are in consensus with them on the maintainability of the petition.
My lord, as far as the limitation part, I am in accord with them because if your lordship sees
limitation and maintainability.
Yes, my lord. As 2013, there were communications.
What about privity?
Privity. Now, privity again. The reason why my learned friend appearing for the HNT contract. The reason why this writ petition was initiated because he was conscious of the fact that without a writ petition, they will not be able to recover anything from the Food Corporation of India. Because if they go in a suit, then arbitration clause will come as a barrier. If they go for arbitration, there might be an award, but that award will not be enforced unless and I recover it from the Food Corporation. So consciously, they preferred a writ petition.
But their claim was made only in 2018. That is one of the.
My lord, as far as the claim amount is concerned, my lord, we had also disputed that because that is not quantified. It is a fact, my lord, that the
So you are
bills,
you are in agreement with them on the ground of limitation, on the ground of arbitration,
yes,
and then on the quantum amount claim.
Yes, madam.
Yes. Yes.
But I shall rely upon only their document to show how they have admitted my entire grievance. State will kindly take up the application filed by the Food Corporation of India, which was placed by my learned friend appearing for the FCI. All documents are, in fact, annexure of my writ petition. Whatever they are placing before your lordship.
Page
77 of the FCI stay application. My lord, now this is addressing to my client in response to my letter dated 11 September. So each and every time, whenever there is a space problem, I intimated my authority, that is the work cell, that this is the position, please advise me what to do. Kindly come to page 77. Kindly see addressing to my client, unloading so and so. This is in response to your letter dated so and so. I wrote a letter to the Warehousing Corporation. This is the situation, what to do. Now kindly come to the last paragraph. In this context, it is also informed that as per assurance given by the area manager, Food Corporation of India, area office, Jalpaiguri, no damage charges will be levied on Warehousing Corporation. So, accrued prior to the taken over the by the accordingly, no damage charges will be deducted, withheld from your admitted bills. This assurance at least on 10 occasions. I shall show to your lordship, whenever I wrote a letter, Warehouse Corporation intimated me, you proceed with the matter, there will be no deduction of damage. That has been assured by the Food Corporation of India, and accordingly, no damage will be levied from your bill.
But there was no such candid assurance from FCA.
No, subject to lordship consider. I have an agreement with the.
Correct. So you are not concerned.
I am not concerned with the FCI. Even before the learned trial judge, I have submitted that Warehouse is the responsible person who has to make the payment, because I have no treaty, I have no agreement with the FCI. By specific case against my lord, Warehouse Corporation, I wrote letter to the FCI also. That's true. Then my lord, kindly come to page 91.
Assurance.
In every time I wrote letter, and it has been assured by the Warehousing Corporation that there will be no deduction of damage charges. Every time. Now, your lordship, kindly come to page 91. These are the amount which has been calculated and ultimately learned single judge passed the order. Every amount has been disclosed by the Warehousing Corporation. Kindly see, my lord. First paragraph. Whatever dues, whatever page 91, 92, my lord. Sorry. Well, first 91. First 91. Kindly see the amount has been disclosed by the Warehousing Corporation, intimating to the area manager, Food Corporation of India. This is a communication of 3rd January 2013. First paragraph. Please refer to this office matter so and so, dated so and so, regarding recovery of 27 lakh so and so by September, November, so on, so amounting to 63 lakhs. Kindly take note, 63 lakhs. Then second paragraph, 27 lakhs and odd. 27 lakhs and 98,000. It has all calculated page 92. Kindly turn up to page 92. Addressing to the Food Corporation of India by the Warehousing Corporation. First paragraph, kindly say 24 lakh 6,700 so. Then second paragraph, third paragraph. First two lines, 27 lakhs 98,000. Then third paragraph, 27 lakhs 6,000. Fourth paragraph, 33 lakhs 56 and also 56 lakhs. These are the intimation to the warehouse by the Warehousing Corporation to the FCI. This amount you have deducted at demurrage charges. And adding this amount comes, what has been directed by the learned single judge. 27 lakh repeatedly submitted before Lordship. Kindly see my last paragraph of page 92 also.
33.94.
Then 56 lakhs.
Plus 56.
Yes, and above that 27 lakhs.
So all three put together is
yes
1 crore.
There is no dispute, and FCI has never given any letter to these communications. They have never denied it. The amount which has been calculated by the learned single judge according to my writ petition, that has never been disputed by the FCI. All amount has been disclosed by the Warehousing Corporation intimating this. Please release this amount. Please release this amount because it is your fault. In each and every paragraph, categorically, Warehousing Corporation intimated them that these are the amount you have deducted illegally, unauthorizedly. And that has been calculated in my writ petition, and I have made prior plea, which has been considered.
Page 93.
Yes, page 93 also.
That footnote, copy to General Manager, WB FCI, last 10 lines, underlined portion.
Yes.
Area manager also aware of the position and understanding gravity of situation, arrange for delivery of the stock for clearance of space, and they did also assure to our warehouse manager that CWC shall not be liable for such detention.
My lord.
The area officer deducted DCWC as stated above, which is quite a surprise to us. We would therefore request and advise area manager Jalpaiguri to release the amount deducted from.
My lord. This is addressed to the General Manager FCI. First letter communication to me, copy to the General Manager indicating them make payment, so that we can hand over the money to the writ petitioner. Now, Your Lordship, kindly come the next page. The entire calculation partly has been given. Page 94. Bill number, demurrage charges, welfare charges. It is not complete. 89, kindly say 83 lakhs 98,000. Bottom. And also welfare charges is there. They are saying, my lord, only 27 lakh. I fail to understand. These are the communication addressed to the FCI. They have never written a single letter. No, these are not the amount.
Then why you waited for almost 5 years?
No, not 5 years, my lord. I shall show to Your Lordship. First letter, 2014, then continuation every letter. RTI application I have annexed all. No response in a single letter. At least 20 letter to the FCI, at least 20 letter to the Warehousing Corporation. Not a single letter, any reply, any denial, nothing. I shall have annexed all. Now, kindly, page 94 is the calculation. What calculation? Addressing to the area manager by the Warehousing Corporation. This has not been denied by the FCI at any point of time, at least in their opposition. No communication has been annexed. Now, Your Lordship, kindly turn to. Your Lordship, kindly take up the opposition filed by the Warehousing Corporation before the learned single judge. That has been annexed in the supplementary evidence. Your Lordship, kindly take up the supplementary evidence. And first, Your Lordship, opposition one paragraph I shall read. Opposition filed by the Warehousing Corporation before the learned single judge, which has been. That is also annexed, no? Take up the supplementary evidence. Take up the supplementary evidence. It has been filed subsequent to the filing of the SW. It has been affirmed on. Affirmed on 11th of November 2024. by the warehousing corporation. In this, they have annexed the opposition, which starts from page, my lords. Kindly come to page 9. Straightway kindly come to page 17. This is the opposition before the learned single judge, which they have annexed in their supplementary evidence. Page 17.
Page
17 of the supplementary evidence. This is part and parcel of the opposition filed before the learned single judge. Have a look. Affidavit in opposition on behalf of the respondent number 4, 5, 7, and 9 to the aforesaid petition. Supplementary affidavit, annexure G, page 17. Have a look, got my lord. Page 17. But kindly turn to paragraph 9 of that petition at page, my lord, 4 of the affidavit. That is page 20, running page 20. With regard to the averments and statements and allegation and imputations made in paragraph 5, 6, 7, 8, 9, 10, 11, and 12 of the said petition, I say that the occasion for the dispute relating to the alleged demurrage charges arose on account of non-availability, insufficiency of storage space at the central warehousing. The answering respondent relies upon the documents annexed in the request. These are the documents I have just placed before your lordship. These are the documents. P2, P6 is by just I have placed before your lordship. Next paragraph. It is pertinent to mention here that by letter dated so and so, so and so, and so and so.
No, sir. I think page number is not tallying. Paragraph 11.
Paragraph 9 of the affidavit in opposition. Paragraph 20, running page 20 of the supplementary affidavit.
Oh, this page 20.
Yes, my lord. I'm sorry, my lord. Page 20.
Yes, para 9.
Paragraph 9. May I read once again, my lord?
With regard
to the averments and statement and allegation and imputations made in paragraph 5, 6, 7, 8, 9, 10, 11, and 12 of the petition, I say that the occasion for the dispute relating to the alleged demurrage charges arose on account of non-availability, insufficiency of storage space in the central warehousing Raninagar. The answering respondent relies upon the documents annexed to the petition from so and so. It is pertinent to mention here that the letter dated 11 September 2012, 19 September 2011, 20 September, these documents just I have placed before lordship. The warehouse manager being responded to in the petition repeatedly informed the area manager, Food Corporation of India, Jalpaiguri being respondent number 8 in the petition about the shortage of space on accommodating rates placement since the would exceed beyond the occupancy so and so allotted to the Food Corporation of India. Therefore, it was also so and so. Then, my lord, kindly come to paragraph 11 at page, my lord, 23. With regard to the averments and statements and allegations or imputations made in paragraph 16, 17, 18, 19, and 20 of the petition, I say that it is an admitted position that the respondent number 8 has deducted huge amount from the HNT bills of the answering respondent towards demurrage charges. The answering respondent has sought for clearance of the said bills and amounts thereunder, which are still pending disbursement. And the said investigation report so and so, so and so. Same, my lord, same page has been annexed. Then kindly come to my lord. Thus, the answer is at page 25, respondent by so and so. It is pertinent to mention here that the regional manager FCI communicated to the so and so area manager FCI Jalpaiguri marked as so and so to the petition and remind area manager Jalpaiguri that as per standing instruction FCI communicated by dated so and so, a separate claim should be lodged on Central Warehouse Corporation for any dues and deduction should not be made from the storage HT charges bill unless the bona fide contract claim so and so. Well, these are the clear admission by the Warehousing Corporation. They are not disputing at any point of time. By saying that whatever has been stated in the petition, we are admitting the same. Claims are genuine, but due to their non-payment, I am unable to make payment to you. So far the amount is concerned, nothing has been disclosed, or these are not the amounts. Because whatever document I have placed before lordship just prior to that, these are all annexures of my petition. Not a single page Warehousing Corporation has stated that these are not the amount. Because I have annexed all the documents written by the Warehousing Corporation to the FCI. And so far delay is concerned, my lord, kindly come to my stay application of the FCI. It starts from, my lord, kindly see, 6 June, page 97. It starts from page 97, 6 June, then it's continue, page 104. Kindly come to page 104. 7 June 2014. Then 108, 10th May 2015. Then 114, 8th April 2017. Every time, both the authorities, not a single reply either by the FCI or by the Housing Corporation. And RTI application I have also annexed, well, kindly see that has not been replied at page 129. No reply. And 131 is also RTI. Not a single letter, at least 15 to 20 to both the authorities disclosing the amount of claim. Never that has been replied, never that has been denied, either of the authorities. (106), kindly onwards, page 106. All the communications. 108, 114, 117, 120, 123, 126, 129. These are all representations. And page, my lord, 129, 131 is the RTI application.
So from June 2014,
yes,
you have been demanding.
Yes. And not a single reply. No answer. Up to 13, there are correspondences. Within 1 year, I started writing letter to both the authorities.
After they withheld
Yes.
the amount.
The moment correspondence has been stopped, I started communication, making communication. Within a year.
The deduction was done in phases, is it? Or one lump sum?
Lump sum. Lump sum. Kindly come to the impugned judgment that has been dealt with by the learned.
That document is there, deduction.
Yes, I have shown to your lordship. Kindly come to my lord page once again.
No, CWC would have, there is not, that document is not.
Page 92. Kindly come to page 92.
That you have said.
Yes. Amount has been disclosed.
Despite the factual position stated, ignoring ground reality, your office arbitrarily deducted so and so arbitrarily. As per the standing instructions, so separate claim should be lodged so and so.
Page 92 of the stay application filed by the FCI Corporation, the entire amount has been disclosed by the Central Warehousing Corporation. Kindly take note of once again, page 92. How this amount reached?
That you have said. This 27.
So this has never been disputed by the FCI also. These are the dues you are illegally withholding this amount.
So the last of such deduction was done sometime in November 2012.
No, this is on a 92 page, 10th of April 2013.
No, that is
demanding money by the warehousing. Yes.
If from your running bill, the last deduction was November 2012. Thereafter, you have been representing from page 97 onwards. That is before that, CWC has been writing to them.
Yes, yes.
They took up
the moment correspondences between the organizations have been stopped, I started writing letters.
Because their caveat started in 2012.
12. And it is continued till November 2000. Kindly come to 2014. Page 94 is dated 20th of January 2014. It has been demanded. There is no delay as I understood, my.
Yes.
And so the arbitration clause is not, your lordship knows, my lord. Because when the one party is admitting the claim.
Now, very recent decision is there.
Very recent decision is also there.
We referred that matter.
Yes.
Where it says it's not an absolute bar.
Absolute, not absolute bar.
In fact, whatever judgment.
It's not a hard and fast rule.
He has relied on. There is another decision in the case of Radhakrishna Industries. It has extracted all like 1960 onwards, Whirlpool, etc., and it has culled out. It's not an absolute bar.
Yes.
There is
Position also saying so, but what are the grounds that has been, my lord?
So it's not an absolute bar. Arbitration not an absolute bar.
This is the basic
Violation of
principle.
fundamental rights, my lord.
Whether arbitrariness was there.
Yes.
Article 14, violation of principle.
Yes.
of
Fundamental right.
lack of jurisdiction.
Those are not applying here. It is my submission, my lord. I will reply, my lord.
Arbitration law, my lord, arbitration clause creates an embargo for a suit, not for an application under 226.
It is there, my lord, but the ground of
Start from my
intervention
lord
is there.
Ramanatha Aram Shetty, everything is there. Possibly that judgment before this bench. And one judgment my learned friend has also annexed in opposition, Justice Soposachi Bhattacharya. Same issue, direction has been given upon the Congress.
That was different because I appeared in that matter. That was different. This is not that had nothing to do with the democracy.
No, so far the maintainability part is concerned. Kindly turn to page 336.
Facts were completely different.
It has been annexed by the Food Corporation of India, page 336. Operative portion, page 343, page 28, paragraph 28. This is contract to the submission made on behalf of the FCI. Because they appeared.
Page
336 is the order of the learned single judge.
Yes.
Operative portion, page 343, paragraph 28. Corporation, Warehousing Corporation has been directed to make payment.
These are factually different. This was a different writ petition. The cause of action was very different. That there was nothing demurrage charges. That those were on account of security money and all these things which were withheld by the Central Warehousing Corporation.
This is Pardiwala's decision.
Yes, Justice Badral.
You are carrying.
Latest decision.
Latest. You circulate that. He, in fact, referred that and distinguished this.
Distinguished. Distinguished. The main theme is the distinguished.
No. Actually, in that it was held, it is maintainable. But in our case, we held it is not maintainable. On facts, we distinguish. You circulate that decision.
And so far the judgment of the learned single judge is concerned.
That your friend has taken through. We have read it once, twice, thrice.
No, so far the amount is concerned, that has been dealt with. I will also see paragraph 17. Page 352.
That
in our page 8. How the calculation came?
That is page 92 letter.
No, right. I'm get close. 92. So, my lord, so far I am concerned, possibly, my lord, there is no dispute that I am not entitled to get the money.
Because right through CWC is supporting you.
Absolutely. They are all paragraphs.
After 2013, end of 2013, they stopped.
They stopped making any further correspondence.
Because
and I started. And not again, I am repeating, my lord, not a single letter has been replied.
And I'll reply only on 3 lines, man. Only 3 lines.
Thank
Three
you.
issues, 3 major issues.
There is one meeting for us, both of us also.
May I come back on other day, my lord?
No.
My reply only 3
No,
lines.
right,
3 lines.
3 lines. I only reply on 3 lines because, my lord, 3 issues only. My lord, why they are supporting him? The question is a very paramount important.
Well, these are my submissions.
My lord, I have engaged, suppose a painting contractor to paint my house. And I have given a contract to that particular agency to paint my whole house within 1 lakh of rupees. And if there is a default, I will deduct the money from him. Now that agency painted my house, but there were certain defects. As per my understanding, I deducted the amount. Now, when I made the deduction, the agency, what he did, he also deducted the same amount from the laborers. And now the laborer is claiming from me. The situation is something like that. Whatever I have deductions I have made, that may be right or wrong. Well, at the very inception, I submitted it. That deduction may be right or wrong. But that issue has not been agitated here in that sense, because that has not been adjudicated there.
But your lower level officers probably were of the opinion that because of the excess rakes being transported.
I have dealt with all those issues in my affidavit in opposition. Since in my understanding, those issues are put on rest because my investigative report has not been challenged by CWC. And those
according to them, it's a unilateral report.
Maybe, my lord. Yes, unilateral report, but the deduction they have not challenged. They have not filed any suit from us, my lord, to claim that amount.
You are under
Whatever-
the same umbrella, sir. How he will file?
He's very much aware of the fact that
He
we
can't
cannot
file
do
a
that.
suit. Then his chairman will lose his job.
Yes, no, no,
In
they are
fact,
not
ours-
doing
No,
this.
no. Where is the affidavit in opposition of
Yes,
it?
my
You
affidavit
just
in
give the
opposition.
page number alone.
Yes, yes, my lord. Affidavit in opposition.
It
It starts from page number 146.
146.
Because they are, my lord, trying to take the advantage.
That
to
we'll go
supple-
through.
Well, to supplement one small fact, the example cited by my learned friend is a good example, but there should be one small condition there, that the wall he provides for painting was wet and damp. Then it equates to this situation.
That is to be a matter of adjudication, my lord, in my understanding. Whether the damage was, my lord, right or wrong, that is to be adjudicated. Whether I did the right thing or the wrong thing. They never challenged the decision. And now, my lord, this writ court in a claim filed by the contractor, that issue perhaps cannot be
No,
adjudicated.
You're right, partially right in saying they didn't challenge it. They didn't challenge it before a legal forum. But
Yes,
they questioned your conduct. And
Yes,
they-
certainly, my lord, certainly.
even prior to your deduction, they said, sir, you cannot burden us with any
Yes, yes,
demurrage
yes,
or
certainly.
warfage
Yes.
because of X, Y, Z.
They disputed, certainly, my lord. they
But you did not dispute that X, Y, Z reasons.
Yes, my lord.
See, both
Because
are,
we have already, we were right in our conduct. So
My lord,
therefore, we.
more so
the
because
fact is, when the rakes are coming in already, if the
Well,
88% storage capacity has been achieved, they write to you saying that, sir, if you send it, it will be 104. We cannot accommodate. So therefore, either you send it to some other godown or rebook the cargo.
Now, in our opposition, my lord, we have submitted the previous occasions also how we conducted the business with CWC in similar fashion. And we have attached those, my lord, letters to show that previously in similar circumstances, they accommodated up to 120%. That is why the investigation
that cannot
report
be a
came.
precedent here. There, the things were different. There was a direction.
All the correctional homes in the state of West Bengal are 250% more than capacity. Do you mean to say what? Suppose the jail superintendent refused to take a remand prisoner. What will happen to his
Yes,
job?
that is true, my lord.
So
But in any
therefore,
event, my lord,
some arrangement, because neither FCI nor CWC is worried about the ultimate person to whom the public PDS rise goes.
right, that is true. To
And,
some extent, that is true.
You said,
For such a long period.
Not a single.
and if suppose you take some action, your senior will come for the MR distributor and he file case and obtain stay.
In that context, my lord, may I humbly submit that my investigation report or my decision was not challenged. That is one aspect.
No, sir.
That, my lord,
Sir,
was never
there is
served
a-
on us.
There is an in-house report. So if you say, this is the finding of my officer, what have you got to say for it? That's it. Obviously, this is inter-department. Under the same ministry.
So I took a
My
decision, my
even
lord.
that
I took
report
a
was
decision,
never
my lord.
served on us.
That decision
We got
remained
the
as it
copy
is.
of the report from the writ petition.
That remained
If-
as it
if
is.
that report-
Now, secondly,
No,
my lord.
writ petition, your writ petition.
My lord,
So
secondly,
if it is not served on us, we cannot take objection to it.
and my lord, secondly,
Not a
let us
single
see one.
person from our department was even invited that come, we are making an inquiry, kindly participate, say what you have to say. It was an inquiry done by them behind closed doors by their officers, and now they are saying it's a decision.
In-house
Be that as
Then
it
how
may,
can
my
that be
lord,
an
be that,
adjudication? I
be
ask
that
myself.
as it may, my lord, this is not the forum, my lord, where the
Correct.
issue
That
can
we
be
have noted.
adjudicated. It is my. Secondly, my lord, my learned senior friend said that the amount that has been reflected in this learned single judge's decision, my lord, it is there in 92, my lord. Let us see it is there or not. It is not there, my lord. May I show? 27 lakhs, my lord, that is there, 27 lakh 98,000. Because, my lord, their letters, my lord, my
There are
learned
three
senior friend.
figures, sir. First paragraph 27, middle paragraph 27, last paragraph 33.94.
No period has been mentioned, and those figures has not been reflected in their claim letter, my lord. Kindly see their letter, my lord, once. What is their letter? Because they have showed this particular letter and 94, where the whole amount has been mentioned. My lord, at the time of my submission, I submitted that all those periods were not claimed by the writ petitioner. Maybe I have submitted rightly or wrongly, but he has not claimed for those
No,
periods.
this is a document between yourself and
Yes.
Yes, this is CWC, and he has writ petitioner is relying upon this document, my lord.
Probably say there may be a genuine case where he has to bear the demurrage
Yes,
for fault committed by the contractor.
yes.
Assuming for some condition he could not arrange for enough number of trucks to transport the grains.
Absolutely.
So then he will accept the deduction.
Yes, yes,
Certain deductions he will challenge.
yes.
So therefore, the privity of contract, one problem is he has no privity with you,
Yes.
accepting your case.
Yes.
Therefore, he cannot lay a claim before you.
No, that I am not saying so, my
Therefore,
lord. What
he
I
has to necessarily fall through CWC.
CWC, very well, my lord. I am not disputing. So let us
All
see,
right,
my lord,
we'll
from his
consider.
letter, my lord, from his letter, whether this amount has been reflected or not.
That we will see.
My lord, kindly see the letter once, only once, my lord, 114, because he is claiming for 3 months only.
92.
September, November 2012, and my lord, September 2013. Thereafter, my lord, there no other period has been mentioned without any clarity, my lord.
But kindly come to page 117.
Very well. Let us come to page number 117. Very well. Second paragraph. In a surprising manner, an amount of rupees 27,98,000 and rupees 63,22,882. My lord, this amount 63 lakhs has been reflected from the CWC as a whole HTT amount, not the deduction amount.
Absolutely not. Absolutely
That
not.
is the total amount, my lord, that has been mentioned, which has been there
There is no
claiming a
objection
deduction.
to that letter also.
No objection.
Then
So
there
for page
are no
92 and
taken
94 is
exception to
concerned,
that.
there is no communication.
There is no exception to that letter.
So for
Very well,
92
my lord,
is
let us see what the CW is saying. Let us see what the
92
CW
is the best of my petition.
And my lord, and 2,94,000 for the bill of September 13. So my lord, period of September 12, November 12, and September 13 they have
My
claimed.
learned is only saying about the 3 months, 3 months, 3 months. What about his submission so far page 92 is concerned?
Now 92.
Has he
Let
given
us
any
see. Let
reply
us
to
see, my
this?
lord. 92.
Has
Very
he
well,
given
my
any
lord.
reply to the warehousing corporation?
Very well,
No.
my lord. Let us
This
see.
cannot be claimed
Let us see 92, my lord. Let us see 92.
because I have not treaty with him.
It is a money
But
claim, my lord.
there was
Figure
a,
has to match, my lord.
no, there was an understanding between both of you, CWC and FCA, that you will not charge demurrage.
That is his, my lord, reference to him. I am not aware of. I have no right.
Sir, please, sir. When page 92 letter, footnote. Don't run away from facts.
Yes, no, my lord. That is written there. That is their request to me, my lord.
True, sir.
Yes,
It
their
is a
request to me, certainly,
not
my lord.
request to you, referring to your area manager's stand.
Yes.
Similarly, if you won't believe the document, they will not believe your inspection report. Inspection report is neither here nor there. It says probably that will be a cause for huge demurrage.
My lord, this letter is saying they are requesting
all right.
us to area manager not
You've
to
heard
deduct,
orders
my lord.
reserved. Thank you.
I'm deputy. Much appreciated.
You circulate, Mr. Bhattacharjee. You please circulate the judgment. Two the decisions are there.
My lord,
Justice
I
Patrial.
have forgotten one decision, my lord. At the
One Radhakrishna Agarwal, another one is Radhakrishna Industries of Justice Chandrachud, and the other one is latest.
My lord, so far limitation point is concerned, I forgotten to cite one decision, additional decision, my lord. That is TNG, where my lord the Supreme Court held that mere exchange of letters.
It will not extend the limitation.
Yes. That reason, I am sorry, my lord, only one copy is here with me. I am sorry.
Justice Patrial's judgment I shall circulate.
At the cost of repetition, my lord, may I submit that the claim letter has no reflection, my lord, in the letter sent by CWC. Those figures and times, dates are not matching, my lord. Maybe paucity of time, I could not establish, I could not represent that thing, my lord. But the letter, my lord, that they are demanding through, they are making the demand, and the letter page number 92 that CWC is sending to us, those figures are not matching, my lord, with the demand letter sent by the petitioner. Though my learned senior
Which paragraph, sir? Which paragraph you will?
My lord. It is in my noting, my lord. My lord, paragraph number 36 to 37, 43 and 45.
Once again, 36 to
37, 43 and 45. Then 47 and 51, 47 and 51. And thereafter, my lord, again 55, 58. In 58, my lord, the ratio has been called out.
It is not open to the party to sit tight and not file an application for settlement of dispute. They were not sitting tight.
It was made in context of, my lord, exchange of letters, my lord. Sitting tight in terms of without, my lord, recourse.
Raising a recourse to law.
Recourse to law, my lord. Here there is no such recourse to law.
Because he is an existing contractor, then they will terminate him.
Until now I am functioning, my lord.
Railway contractor, FCI, CWC, very difficult. It will appear to be big money, but very
in this case, my lord, we are supposed to pay them. Since we have deducted, that has not been, my lord, challenged. Now, if the decision remains, my lord, then that, my lord, the decision has been set aside because they have no challenged that decision. So, but deduction is concerned, my lord. The deduction that we did, my lord, 27 lakh, only that amount has been, my lord.
They can't come to you, sir. You will not open the door. You will say, who are you?
No, I'm
talking
about CWC, my lord. I'm talking about CWC.
CWC is supporting them in so far as the levy of.
Yes, so they could have challenged that decision,
right.
my lord.
Send
They could have challenged, my lord.
one file to me, one file to you.
Chief of the Honorable Chief Justice, I want to mention regarding one matter which is assigned to the Chatterjee Lordship. Because this is a very urgent matter, Lordship, because this is a Panchayat tender matter. It is not heard, it will be in
Oh, we will hear it. Tomorrow it will be here.